let's get at it. And we're in the throes of our licensed law and commission rule. And before we go there, and we'll do some reminders on dates and everything in the next couple on a little bit when we know we have everybody on. But with licensed law and commission rule, specifically, we're focusing on the comments. So we talked about how there's licensed law and there's commission rule, which is going to be this little piece, this first piece here. But what we're focusing on right now in this discussion is just the comments. And we have some other things that we need to go back and pick up that aren't part of the comments, but they are part of licensed law and commission rule. So of course we'll do that. So we started trucking our way through the comments the other day, and we made it. We are, let's see, we are on page 10 of this thing. It's kind of weird that it's 2 columns, isn't it? Sometimes I think it's easier to have this in your hand. However you see it though. But we finished the first column on page 10. So where we are today is starting with the second column on page 10, talking about some general brokerage issues. And as you can see where we're heading next, and I think this serves as a great review, is we have the opportunity to review some things on agency, but specifically on agency, the state side of it, the state specific stuff, since we're in the licensed law and commission rule. So remember, let's talk about our written agency agreement. Note that word says written agency agreements. And we're talking about our agency agreements, they're employment contracts. We're being hired to do a specific job, and the agency agreement dictates what that specific job is. Anytime we are doing anything for an owner, may that be a seller or a lessor. The lessor is the giver of the lease, or the landlord, or the owner. Whenever we're doing anything for an owner, all agency agreements have to be in writing from the onset. I cannot perform a single service for an owner without a written agency agreement. Is everybody hearing me? If I may word that another way, we can't do oral agency for sellers or lessors. Written only. From the beginning, from the onset. As soon as they say, we want you, we need to get that thing in writing. Buyers and tenants are a little bit different. Eventually, we have to have them in writing. And part of the big reason why we put them in writing is to protect our commission. It's the only way I can guarantee that you'll get paid if we have that agreement in writing. So that covers that. Remember as well, with the buyers and the tenants, we are allowed to act under an oral buyer agency agreement at first. This is an express agreement. We talked about several times, we talked about express versus implied. And with an express agreement, an oral buyer agency agreement is express, meaning that the terms have been clearly stated. Maybe those terms were stated orally, maybe those terms were stated in writing. Doesn't matter. An express agreement just means that the term has been clearly stated. So the commission will allow us to work under an oral buyer agency agreement at first, or an oral tenant agreement. But both of them must be put into writing, reduced to writing. I think a good way to remember it, all agency agreements got to be in writing by the time we're ready to present or receive the offer. So if we're going to make any changes to dual agency, maybe the seller originally said no to dual agency and then they changed their mind, I got to get that change in writing. And specifically, I got to get that change in writing before we're ready to present the offer. That present the offer is kind of the deadline for these agency agreements. So buyers, again, we're allowed to work with under an oral agreement at first. But guys, remember, there's no requirement that says that you have to. There are a lot of agents, there are a lot of firms out there that say, no, we're going to do all buyers in writing. This is where I fear sometimes we get in our own way. Some of you may be sitting here thinking, well, I'm not going to do oral buyer agency. And I think that's great. Your test is not going to ask you what you're going to do. Your test is going to ask you what you can do. You can, the commission will allow you to practice oral buyer agency at first, know when we need to put that agreement in writing by the time we're ready to present the offer on behalf of them. Also addressing our agency agreements. This is a nice review for us. We talked about our 4 musts of all written agency agreements. Must meaning what? I can see mouths move. Is it optional? Can we choose, decide? Nah, must means this is the requirement. If we're using a written agency agreement, essential, perfect. If we're using a written agency agreement, these are the 4 musts. Obviously, if you're using NCAR forms, these musts are included, but the concern is, what if you go out and create your own agency agreement? You hire your own attorney to have your own agency agreement for you to use going forward. This is where this is important, and we need to know these 4 musts. So the written agency agreements must be signed by all parties. It's going to be between the firm and the client. So the client could be the seller, the buyer, the owner in a property management situation. In addition to the client signing, we have to have a signature of the firm, but since the firm is an entity, the entity is unable to physically sign because the entity is not a person. So more often than not, brokers will be signing the agency agreements on behalf of the firm. And because we are the one signing on behalf of the firm, another must is that we include our license number. So I told you guys, once you get licensed, you'll get a 6-digit number. Go ahead and memorize it. Take that as your free advice for the day, because you're going to need it everywhere you go. When you're dealing anything in real estate, you need that license number. I often joke that the Real Estate Commission has no idea who Julie Yates Campbell is, but you ask them about 264172, and they'll be able to let you know. So memorize that number. They have to have a definite end date. Remember, all agency agreements have to have a definite end date. And when they're over, they're over. We don't need to give each other notice because we've already decided how long this relationship is going to be. Can we agree to extend them? Sure, absolutely. But we're going to extend it to another definite end date. We can't have this outstanding ongoing relationship. We all have to understand when this is going to end. Remember as well, you guys, in the property management agreement, there is an exception just for the property management agreement. And that agency agreement will allow for us to have an automatic renewal. So we can carry that relationship over and over and over again. Remember, the idea of the property management relationship is that we want to create a long-term relationship. We want the owner and the investor, the investor and the broker to have a long-term relationship. So the property management agreement will allow for an automatic renewal. And then the other must, all of our written agency agreements have to have our non-discrimination clause, letting the clients know that we will not discriminate based off of the protected classes. So let me back up for a second, because on the last slide, we mentioned that oral buyer agency. We said it's got to be express, which means the terms have to be clearly stated. That's how we get away with it. Also, remember, oral buyer agency is agency. When you guys see that word oral buyer agency, I suggest that you cover up the word oral so that we can see what we're dealing with as buyer agency. And in an agency agreement, don't I owe my client OCAR? It is an agency agreement. We just haven't put it in writing yet. We have up until the time we're ready to present an offer to put that in writing. So what if? What if? Your buyers found the house. They're ready to write it up. You write it up. They sign it and you're ready to present it. You say, oh yeah, before I present this offer, I got to put our relationship in writing. Here, sign this buyer agency agreement. And the buyer says, Yeah, no, I'm not going to sign that. What if, what if, what if? Understand in that scenario where it stands right now, I cannot present the offer on their behalf. We got to figure out what else to do. Because if I don't have their signature in writing, I cannot proceed. So now we got to back up and we got to figure out what our other options are. So, what are our other options? Well, remember, our buyer agency agreement allows us to create buyer agency just for one address. So I could create a written buyer agency agreement for 123 Main Street so I can present the offer on their behalf. If it gets accepted, I'm their agent from contract to closing. If it doesn't, then we still have an oral buyer agency agreement. We can get back out, find them another property, and go from there. If that first one doesn't, if they do the one address and they're hesitant to sign the whole thing, I would kind of find out why, right? Why are they hesitant? Why are they reluctant to sign? And honestly, I think a lot of the times the whole reason why the commission will allow oral buyer agency anyway is so we have time to build that relationship, to build that trust, to gain their trust, and let them realize that I am in their best interest. So if we're at this point and they're unwilling to sign, I would go back to the table and find out what's up, find out what's going on, what's causing their hesitation. They still won't sign. You're trying to get them to do buyer agency for one address and they won't do it. But they're looking at you going, I just want this house, just present this offer. Our only other option at that point would be to offer to downgrade them. Well, as an oral buyer agency, I had you in coach, but you're refusing to sign to be in, not coach, first class. I'm sorry, I had you in first class, but you refuse to sign. So if you refuse to sign, but you want me to proceed, I got to downgrade you from first class to coach. In agency speak, I got to downgrade you from a client to a customer. Remember, seller sub agency, the buyer is the customer. Is the buyer going to like that? Does anybody like to be downgraded? Right? They may not like that. Before we do this, though, hold up. Before we do this, we need to first off make sure that the listing firm and the seller will allow seller sub agency. Remember, when we look in our MLS, it tells us if they'll allow seller sub agency. And if they do, then I need to go back to my buyer and remind them what I know about them. Because as soon as they downgrade, they're switching the side of the agency line. As a client, I'm on the buyer side, holding hands with the buyer. And if I downgrade them, I move them to the seller side. Whose best interest do they have now? The seller. Whose best interest do we have in seller's sub agency? It's the seller. And if that buyer's going to downgrade, then I need to say, okay, I know your motivation for buying. I know how high you're willing to go. And as soon as you require me to switch sides, I now have a duty to share that with the seller. Can we see why downgrading isn't the ideal, the optimal solution? Let's call this downgrading last ditch effort. We got this person that won't sign the buyer agency agreement, but they really want us to present the offer. As long as I have the listing agent, the seller agreeing to allow me to proceed as a seller sub agent, as long as the buyer agrees in writing to be downgraded, then I can make that switch from buyer's agent to seller sub agent. Last ditch effort, you guys. And I think we can understand the dangers. What if? What if they say, no, I'm not signing that agency agreement, and no, I'm not downgrading. That's it. I'm out. I have no other legal alternatives. Either you're my client or you're my customer. We don't have a secret option C. Is everybody with me? What questions do I have about this? Anything on our written buyer agency agreements? Another nice little review for us is our agency disclosure. Working with real estate agent disclosure is a state-specific thing. Not all states have said disclosure or any type of agency disclosure. So for unlicensed law and commission rule, working with real estate agent disclosure. Remember, this applies to sales transactions only. Y'all watch out for that word all. Does it apply to lease transactions? Shake your head yes or no. Does it apply to lease? No, it applies to sales. Is everybody with me? So if it doesn't apply to lease, does it apply to all real estate transactions? Watch that word all and don't forget about the lease side of it. So sales transactions only, if I can word that another way, when you're working with buyers and sellers. The working with real estate agent disclosure is required. A commercial sale is a sales transaction. So commercial and residential sales. And we have this duty to provide no later than or at the time of first substantial contact. After first substantial contact is too late. So we need to be on alert for first substantial contact. We either need to, if we know we're going on a listing appointment or a buyer consultation, there's a really good chance we're going to hit first substantial contact. So let's do our early. If you meet somebody at an open house or they call you off of your yard sign, we need to be alert. And we need to be prepared to say, I'm so sorry to interrupt you, but I need to let you know my agency status. I need to disclose my agency status. And the big thing about the agency disclosure form, remember you guys, this is a consumer form. Consumer, maybe you'll be my client, maybe you'll be my customer, maybe I'll never see you again. This is a consumer form. And the important thing that the consumer needs to understand is that I don't owe you confidentiality until and if you decide to hire me. So what if you never decide to hire me? I never owe you that confidentiality. And that's the big point of the form. It allows us to explain that to the consumer so they can be careful what they say to us until and if they decide to hire us. Disclosure of agency status by the seller's agents and sub-agents, to prospective buyers. So this slide is addressing, you've already been hired as a seller's agent or you're acting as a seller sub-agent. And on behalf of this seller, you are talking to a prospective buyer. Commission rule says we have a duty to disclose our status in writing. We can use the working with real estate agent disclosure to satisfy that to that prospective buyer at first substantial contact. So these are the examples we gave of a buyer coming into your open house or calling off your sign. You have the listing, you have the seller, or you're acting as a seller sub-agent, and you got a prospective buyer reaching out. They have a right to know, as a case of a seller's agent, they have a right to know that you represent the seller in that transaction. And anything you tell me, you might as well be talking directly to the seller. If you don't want the seller to know how high you're willing to pay, how much you're willing to pay, then don't tell me. If you don't want your seller to know your motivation for buying, your timeline for buying, then don't tell me. Also, buyer, understand that because, as an example, I'm acting as a seller sub-agent, I don't owe you confidentiality. The one that was a little bit different then with agency disclosure is if you've already been hired as a buyer's agent and you're reaching out to the seller or the seller's agent on their behalf. Does everybody hear the difference? First one, you've been a seller's agent, first substantial contact. Now you've already been hired. You are acting in the capacity of a buyer's agent, and you're reaching out to the seller's agent on behalf of the buyer. I now have a duty to disclose that I'm a buyer's agent at initial. That's me calling the listing agent. Remember your buyer that has severe allergy to dogs and they want to go see 123 Main Street this afternoon? I have a duty to call the listing agent and ask some questions about 123 Main Street, don't I? Why go show the property if they have 5 dogs that live there? We know your buyer can't. So my buyer wants to see 123 Main Street. I call the listing agent and I say, hello, my name is Julie Campbell, and I'm representing a buyer, or I'm working with a buyer that's interested in your listing at 123 Main Street, and we have some questions. When did I tell them about my role? At initial. I didn't wait for that conversation to proceed. Another state-specific thing, dual agency. Not all states practice dual agency. Some do, but not all don't. So this would more than likely be a state-specific. All right, everybody show me. I want to see everybody's hands up. Show me, dual agency. How many firms? How many firms in dual agency? One firm. It's an in-house transaction. How many firms? Everybody show me. One firm. How many transactions? How many property addresses are we dealing with right now? One transaction. One firm, one transaction. How many clients? How many clients? 2. The seller has hired the firm to sell 123 Main Street. The buyer has hired the same firm to sell, or to help them buy 123 Main Street. Okay, bonus question. Get your hand up one more time. How many customers? Trick question. How many customers? Customers. If both parties are your client, remember, you can either be my client or my customer. So if the buyer and the seller are the client, then how many customers do we have? 0. That's what makes dual agency so tricky. So remember, in dual agency, please write this down. You have it written down already. You did what I asked you to, but write it down again for fun. Dual agency is about the firm. Write that down. Dual agency is about the firm. So in dual agency, you have the firm and all of the agents straddling the agency wall. On one side, you have the buyer. On the other side, you have the seller. Is anybody hanging out with the buyer and the seller? No, because all the agents are straddling the wall. We can still represent them. We can still have their best interests. We can still get them through the transaction. The thing that goes away in dual agency, the big thing that goes away in dual agency, is advocacy. I can't be an advocate for one party without harming the other. And in dual agency, we're not going to be able to offer advice. In dual agency, we need to pay attention for questions that start like, should I do this? Or do you think I need to do that? That advocacy goes away in dual agency. And we're straddling the wall. All of us, firm and all the agents, are straddling the wall. Remember our football example? Prior to dual agency, we were coaches. Once we enter into dual agency, the broker's roles have to change. The firm's role has to change. The firm and the brokers can't be coaches in dual agency. So the roles change and we can proceed as the referee. We're still involved in the game, right? We're still a pretty important part of the game. But is the referee telling the quarterback what play to make next? I know, unless it's the New England Patriots. But other than that, right? Okay. So other than that, is the referee telling the players, telling the quarterback what to do next? That's what we're saying, dual agency. We're making sure everybody's there to get through the transaction, following the rules. One firm, let's write this down. One firm, one transaction, two clients, zero customers. We'll revisit designated in just a second. We briefly mentioned auction sales. Auction sales are a totally different bucket. They're a totally different category. I don't want you guys to even think about an auction sale unless the question specifically says something about an auction sale. If the question or the answer choices don't say auction, then pretend like it doesn't exist. Everybody hearing me? I need you to see the word auction. If you do see the word auction, it may come up for the fact that the auctioneer doesn't need to do the working with real estate agent disclosure for the seller. The auctioneer doesn't need to do working with real estate agent disclosure for an unrepresented buyer. If the buyer comes represented, then their agent will need to do a working with real estate agent disclosure. But the auctioneer, they're exempt from the working with real estate agent. You're also not going to have dual agency because the auctioneer, they're dual licensed. They have a real estate license and they also have an auctioneer's license. And because of that relationship, because of that two hats that they're wearing, they're not going to represent the buyers. So if the buyers are represented, it's from their own, it's from another firm. So the buyer's agent still has to do with a represented buyer. But auctioneers, that's the one exception to the working with real estate agent disclosure. Here's our dual agency that we just said. In-house transaction, meaning one firm. In-house, meaning we're all within the same firm. One firm, one transaction, two clients. Maybe it's one broker acting as a dual agent. Maybe it's two, but it doesn't matter because dual agency is about, say it with me, dual agency is about the firm. Have the firm and all the agents straddling the wall, given equal loyalty. Because dual agency is about the firm, technically speaking, agents can share information about their buyers and sellers with each other. We can't share that with the other party. Even though we're in dual agency, we still have that duty of confidentiality. I can't tell. Just because I'm in dual doesn't mean I have a golden ticket to share my buyer's secrets with my seller and my seller's secrets with my buyers. The idea of brokers discussing, the firm very well may have a policy against that. But again, the idea behind dual is that if we're all representing this buyer and seller, we all know the same thing. We all have the same information. By the way, if you have a firm with multiple office locations, we're still in an in-house transaction. I'm not talking about under the roof. I'm talking about under the firm. One reason firms may have a policy against you guys blabbing each other's clients' confidential information, run around sharing each other's secrets, could be if the firm practices designated dual agency. And in designated dual agency, it's a form of dual, which means I have to have consent to do dual before we can agree to do designated. If either party says no to dual, then designated is not an option. But if I have both parties saying yes to dual and the firm allows designated, not all firms practice designated. I need you guys to see in the test that the firm offers designated. Don't assume, because we like designated better than dual, right? Designated sits easier with us and we like it better. So we all want to do it because that's what's better for the clients. But I need you guys to see that the firm offers designated. Don't automatically put designated in. So it's a form of dual. Now I can only have 2 brokers. And in designated, one broker gets kicked off the wall to work exclusively with the buyer, and a different broker gets kicked off the wall to work exclusively with the seller. Do you guys hear my key word there? Exclusive. When you see that word exclusive, I want you to pause and ask, how many firms is the buyer dating? How many brokers is the buyer dating? That word exclusive means a whole lot. So we got 2 brokers that have been kicked off the wall. One is exclusively representing the buyer. The other one is exclusively representing the seller. What happened to the firm and the rest of the agents? Did they get kicked off the wall too? They're still there straddling, right? They are still in dual agency. Designated doesn't eliminate dual. Designated just allows exclusivity to come back. Now that these 2 agents have been kicked off the wall, both of these agents might as well proceed as if they were with 2 different firms. These brokers' roles have just changed again. You went from being the coach to the referee, and now you're designated. And guess what? The 2 brokers only get to go back to being the coach. They can offer advice. They can be an advocate for their client. There are 2 caveats with designated. Well, you can't be designated if you have received prior confidential information about the other side. You can't be kicked off the wall to exclusively represent the buyer if you know something confidential about the seller. Are you going to harm the firm's seller? Possibly. The firm still has to protect their clients. So you cannot be designated if you have prior confidential information about the other side. The other big thing, probably the number 1 problem topic in Unit 7, is that the provisional broker and the broker in charge cannot be designated opposite of each other. Yes, no question for you. Shake your head, yes or no. Can the PB and the BIC be in dual agency together? Shake your head, yes or no. Can they be in dual together? And the answer is yes, because dual agency is about, say it with me, the firm. They cannot be designated opposite of each other. Correct. The reason being is because the nature of the relationship. We now have a better understanding that as a PB, remember the BIC is your training wheels. You can't ride your bike without your training wheels. The BIC is pretty much in your back pocket as a PB when you're first getting started. So there's a really good chance that the BIC prepared you for, if not went with you on that listing appointment and that buyer consultation. Because they're so hands-on involved, they're side by side, they're in your back pocket. Doesn't it stand to reason that they know something about your buyer or seller? Because they're so involved, or should be so involved. So the nature of the relationship is why this is what it is. Any other relationship is allowed as long as they don't have prior confidential information about each other. So PB can be designated opposite of a PB. A PB can be designated opposite of a full broker. Of course, broker and broker can be designated opposite of each other. Broker and BIC can be designated opposite of each other. All these relationships are allowed as long as you don't have prior confidential information going into designation. So PB of another BIC can be with it. So now we have a cooperating. We're not in-house. The PB only has one designated BIC. So other BICs are different firms. One under each roof. There's a BIC under each roof. So could the PB, I mean, this is stretching it again, I don't want to cause confusion, but could the PB of office location A be designated against the BIC of office location B? Technically, because B's BIC isn't A's PB. You're not going to see that on your test though, right? What we're saying here is the PB's designated BIC, the BIC of A, the PB in A. If you're acting as a single agent, dual agent, even though you're a single agent, dual agent, you know everything about everybody, but we still have a duty to keep the party's confidential information confidential. Other general brokerage provisions, things to know. General brokerage provisions covers brokers as parties to the transaction. When you are representing yourself, selling a property that you own, if you're representing yourself buying a property, if you're representing yourself to lease a property. Remember we said we're going to be held to a higher standard because we're the licensee in the transaction, even though we're also acting as the seller or buyer. When it comes to who we can represent in this situation, if you are representing yourself, you're the listing agent and you're also the seller. Your name is on the deed or your spouse's name is on the deed. We cannot represent the buyer in that same transaction. My name is on the deed. Old car says I should have my buyer's best interest. But let's face it, if my name's on the deed, whose best interest do I actually have? We can see the conflict of interest here, yes? Somebody else in your firm could represent that buyer, but we cannot represent the buyer in that transaction. The exception to this rule is if you own a commercial property and your ownership interest is less than 25%. 25% ownership interest or less on a commercial property. You can represent the buyer in that transaction as long as you go into it with full disclosure. You got to let that buyer know, I own 20%. Y'all think you should get that full disclosure in writing? Yeah. Because what do we document? Everything. General brokerage provisions. We have a duty to notify the commission of a change of our name, address, email, and we need to do so within 10 days of the change. If you get married and you change your name, if you get divorced and you change your name, if you move, if you update your email, just log into the commission's website and within 10 days and change your name or your contact information. Once you get licensed, you guys will have a licensee log on the commission's homepage. You may have seen that button that says licensees log on, and you'll be able to access through there and access your account, see your information. If you have a change in any of your contact information, then you can update it through that as well. So it's just a matter of logging in and update it. Just do it within 10 days. That's the key there. Both change the name, personal or business, both. Yep. There's more involved with your business name. If you want to set up a business name, maybe it's no, you're not using your assumed name. Like if I wanted to create a real estate firm called Julie's Real Estate Shop, that would be my assumed name. But if I created a real estate firm and called it Houses Are Us, then I would need to create my business name. You guys will get that. That's coming in 303. That's coming in your post licensing. So you'll get a lot more about setting up a name, setting up your business. All that's coming in post licensing. There's some commission rules on our advertising. We've already said I have to have a written agency agreement before I can do a single service for an owner. So our advertising guidelines piggyback off of that. They say I can't advertise somebody's home for sale or for rent without having that written consent. Written consent meaning our written agency agreement. So I can't do any kind of advertising. I can't do anything for an owner without first getting that in writing. The BICs are responsible for the firm's advertising, all advertising that comes out of the firm. Full brokers and provisional brokers, because the BIC is representing the firm. So want to make sure that you have your BIC, and your BIC will go over their policy with you when you affiliate, when you join. Your BIC will go over their policy about how they want to review your ads before you hit submit. We know how the internet works. Once it's out there, it's not as easy to get back. So put a second set of eyes on it before you hit submit. Social media, internet advertising, print media, any form of advertising. The BIC is, making sure the verbiage is good. The BIC wants to make sure we don't have any potential fair housing violations. Just in general, that it's a good ad. Another thing a BIC may want to check on is to make sure that you're branding the firm properly. The firm has branding. It's how the people recognize the firm. So your firm's logo, your firm's colors. My firm's colors are blue and white. Not just any shade of blue, but a specific shade of blue. My branding would not be to put something out there with a green and pink logo. People don't recognize that because that's not our branding. Does that make sense? The best example of branding I can ever think of are our golden arches. We know what's ahead when we see those things, right? That's your branding. So the BIC may want to make sure that you're branding the firm properly. Another thing with advertising, and the big thing with advertising, we're not allowed to have blind ads. A blind ad is one that doesn't identify the firm. Remind me, whose listing is it? It's the firm's. I can't put an ad out for a property for sale without listing the firm. If you're advertising your brokerage services, call me, I can help you buy. You're advertising your brokerage services under the firm. So we need to see the firm's name. And we need to see the firm's name. You can't have it like embedded in an email or a website. You need to actually see the name. So for example, if my email was, Julie@kellerwilliams.com, that's not sufficient. We actually need to say Julie Campbell with Keller Williams, for example, list it in the ad. And yes, this also applies to social media. Yes, we could all go to Facebook on break and find violations of this. No, that doesn't make it okay. It's not a problem until it's a problem. And now it's a problem. Questions on advertising? Right, hold your hand up. I got a question where the answer is going to be a number. So hold your hand up. Get ready for me. Who remembers how many days we have to deliver instruments? Yep. Commission rule, general brokerage provisions, delivery of instruments. We have a duty to deliver executed documents, executed instruments within 3 days of our receipt or execution. First off, let's talk about what the heck an instrument is. An instrument is just any document related to this transaction. I think a good rule of thumb, what do we send clients? What do we send customers? A good rule of thumb, if they sign it, they deserve a copy of it. Every single one of us on this call are consumers. Don't you want a copy of something you sign when it's something like buying a house or a car or something like that? So good rule of thumb, if they sign it, send them a copy of it. Our relationship generally starts with our agency agreements. So we have our working with real estate agent disclosure and our agency agreement. We get that signed, we've created agency. Now I have 3 days to send them a copy of that signed agency agreement, 3 days to send them a copy of that signed working with real estate agent disclosure. Fast forward to the contract paperwork. Congratulations, we're under contract. I have a signed contract. Now I have 3 days to send them the copy of the contract and all applicable addenda. And then fast forward one more time to the closing. I have a duty to deliver the signed closing documents within 3 days of execution, meaning signatures. Also note that that word says deliver. That's my job. What they do with it when they get it, I don't care. My job is to get it to them. If you do it in an email and attach a PDF, don't you have documentation of the date and time you delivered it? Don't you have documentation? There you go. If you hand it to them in person, I suggest asking them to sign something saying that they've received it. Document everything. The exception to this rule, kind of, not really, but we'll call it an exception to this rule, is when we're presenting offers to sellers. When we're presenting offers to sellers, we have a duty to present those offers immediately, but in no event later than 3 days. So when do we deliver offers to sellers? Right now. But in parentheses, no event later than 3 days. Okay, hand up. Another question for you that's a number answer. I'm kind of giving you a hint here, right? Because I'm only saying one hand. So you know it's 0 through 5. How many years do we have to retain records? How long do we keep everything that we're documenting? Good job, guys. Retention of records, we keep everything. If we're going to document it all, why aren't we keeping it all? Agree? So we retain everything for 3 years, all records. Advertising, if you put something on social media, take a quick screenshot of it. Now you have your documentation. You're going to write an ad in the paper, run out and buy a copy of the paper so you have your so you have your ad. Any notes, of course, any of your signed documentation would be a record. Any of your notes, emails, text message, correspondence about this transaction. All those CMAs that we're doing throughout the transaction. Listing agents, your measuring sketches, graphs, proving that you measured or showing whomever you hired measured it. Keep it all. If it's related to this transaction, keep it for 3 years. And then commission rule goes on further to say from the successful or unsuccessful conclusion of the transaction. Successful meaning it closed, unsuccessful meaning it didn't. Whenever the firm's relationship is done with the client, may that be at closing, may that be when we terminate, may it be when we expire. When the firm's relationship is done with the client, that starts our 3-year clock. Questions on our delivery of instruments or retention of records? Commission rules. Let's take a break. We come back, we'll keep trucking along at our comments, get into license law and commission rule. So let me take attendance. Shay Maria, I got you guys. Okay, general brokerage provisions, continuing on. Gotcha, thank you. Another brokerage provision addresses our commission, our fees. The big picture of this is disclosure. I can't make a secret profit. I can't make money that my principal or my client doesn't know about. Specifically, my disclosure on my compensation and fees must be done in a full and timely manner. Let's say, for example, your buyer's buying a new construction and the builder's offering a $500 buyer agent's bonus with all acceptable offers by the end of the month. Do you have to share with your buyer that if they buy this new construction property, you're going to make more than the agreed upon commission? Do you think that's information for them that they need to know? Absolutely. Absolutely. We're going to stand to make more. We're going to make $500 because they bought this house. Don't they have a duty to know that? And that's what we have to do is disclose, disclose, disclose. Full disclosure means you say, if you present an offer, if you purchase this home, I should say purchase this home, I'm going to make $500. You can't just say I'm going to get a bonus. Full disclosure, and then timely, meaning we got to do it before we present the offer. Remember, everything is in writing as far as agency before we present the offer. It's not like we can wait until we're sitting at the settlement table and say, by the by, as soon as you sign, I get $500 extra. Full and timely disclosure. What we're saying here, you guys, is they need all of the information to take everything into consideration when they're presenting this offer, when they're making this offer, and that does include our disclosure. We have an agency agreement saying that they agree to pay us, or they agree that we should be paid X amount from the transaction. But this would be in addition to our compensation, etc. Restrictions on compensation disclosure. I don't disclose my commission to my customers because we don't have anything in writing. Only my clients have something in writing. So customers don't need to know what it is. Thank you. Customers don't need to know what it is I make. The other restriction when it comes to our commission, the only thing we're disclosing is what the firm is collecting. It is nobody's business what my split with the firm is. So if the firm's collecting, I'm making numbers up. If the firm's collecting 4%, that's what we disclose. If my compensation split with my firm is 70-30, none of your business. We don't have to disclose that. And then the real estate commission doesn't get involved with matters of money. So they're not going to get involved with how you're paid from your firm. They don't get involved with how much your firm charges. They don't get involved with fees, anything like that, except the exception of the timeshare. The way I always remember it is exactly how you're looking at it. Commission doesn't do commission. Commission doesn't do money. We've talked about the unlicensed person. We talked about them on Thursday, how that unlicensed person is paid. They got to be paid on an hourly or salary transaction. They cannot be paid per transaction. So when you get to the point that you're ready to hire somebody to help you out, make sure you're paying them hourly or salary. And then at Unit 21, we talked about RESPA. RESPA is the R in TRID. And RESPA gives us some regulations. And one thing that RESPA prohibits is payment to or from settlement service providers for recommending settlement service providers. So a settlement service provider is somebody that provides a service during the settlement process. Brokers, attorneys, lenders, inspectors, surveyors, appraisers, all those people that, it takes a village to buy a house, right? So let's say the villagers, we cannot give or receive settlement service providers for recommending services. So if you suggest your buyer talk to a home inspector, the only thing that home inspector can do is call you and say, thank you. General brokerage provision covers the BIC. Revisiting this, we have one designated broker in charge at each office location. Oh, there it is right there. One designated broker in charge at each office location. I got to have a BIC under every roof. So I think the example we gave, you affiliate with a firm and they have an office location in Greensboro, they have an office location in Burlington, they have an office location in Raleigh, and they have an office location in Fayetteville. How many designated BICs does that firm need? One under each roof. Designated broker in charge cannot supervise more than one office at a time, so that, again, one under each roof. At some point in your career, you may want to go out on your own. You may want to start your own firm. When you're ready to do that, revisit license law and commission rule, revisit the commission's website to make sure you're proceeding properly. But when you're ready to go out on your own, when you want to start your own firm, you have some options. You may be able to start your own firm and become a broker in charge. We'll talk more about that in a second. But another option might be to practice as a sole proprietor. The word sole tells us how many people are with this firm. Sole meaning one. Sole proprietor or sole practitioner, you may see. And if you choose to go as a sole proprietor, depending on the activities that you're going to do, you may not have to have a designated broker in charge. As a sole proprietor, you don't have to have a designated BIC if you're not going to have a trust account. We're getting ready to talk about the trust account. You don't have a designated BIC if you don't have anybody else affiliated with you. If you are in fact sole and you have no brokers affiliated with you, you also don't have to have a designated BIC if you don't plan on advertising your brokerage services. Your business is referral business. And that referral business is from those that should reasonably know that you have a real estate license. You cannot advertise your services as a sole proprietor without having a designated broker in charge. You could be your own designated broker in charge. Generally speaking, then, the sole proprietor without a BIC, because they're not advertising their services, they are in the referral business. This is the second piece of my retirement plan. When I'm ready to retire, I'm going to hand my book of business over to somebody. And we say, here's my book of business. Every business you get from this book, I want a referral fee of X amount. I am solely in the business of referring. Does that make sense? I could proceed as a sole practitioner, but the moment I go on Facebook and say, call me to help you buy or sell, I have advertised my broker services and I got to have a designated broker in charge. Yeah, family members, mom and dad, my bestie, my spouse, right? The people that would reasonably know that I talk to. Yep. That's the key with the sole proprietor. You can be a sole proprietor with a designated BIC, but you don't have to have a designated BIC as long as you're acting on referral status. No, you're referring. Because you could act as a buyer's agent, but you don't have access. You're probably not an MLS, right? It's referral is what we're getting at. If you want a BIC or if you want to become a BIC, first off, you have to become BIC eligible. You guys already have this written down. We saw this on Thursday. So to become BIC eligible, 3 steps. You got to have an active license, non-provisional status. That makes sense, doesn't it? You don't want our BICs being PBs. So an active license, no PB. You have to have some field experience. So they're looking for at least 2 years full-time, 4 years part-time within the past 5 years. And then you have to complete, there's a 12-hour BIC course. This makes you BIC eligible. Once you're BIC eligible, then you are eligible to become the designated broker in charge. May that be a designated broker in charge of your own firm that you just created, or may that be designated broker in charge of a firm that you're affiliated with. Again, more on firms and creating firms and naming your firm and registering your firm and all that good stuff. It's coming in post licensing. The designated BIC has got to keep their BIC eligible status. And they do so by renewing their license annually. We're going to talk about the renewal period in just a second. And they also have to keep their license on active status. If they fail to renew or fail to keep their license on active status, they lose that BIC eligible status. And once you lose that BIC eligible status, if you decide you want to be a BIC again, then you got to retake that 12-hour BIC course to get that BIC eligible status back. We'll talk about renewal. We'll talk about active status. We're getting there. So if the designated broker in charge of a firm or an office, designated broker in charge of an office fails to renew their license goes inactive and they lose BIC eligibility status. The firm will also go inactive until they can find another designated BIC. We always have to have an active designated BIC in place for the firm to have an active license. If this happens, if your BIC, BICs pass away sometimes. BICs don't show up to work, right? They ghost you and they never show up again. So it happens. The firms need a backup plan. They need a plan B. If they don't have a plan B and this happens, what if the BIC passes away? The firm's license goes inactive. Full brokers can continue because we don't have to have affiliation to have an active license. But what do you think that happens to provisional brokers? If the firm's license goes inactive, what's that do to your license status? You're going to go inactive as well. You got to be affiliated with an active firm in order to have an active status. So your BIC, again, we're going to talk about the renewal period, which started yesterday, actually. So BICs all over the state are starting to look at their licensees and going, don't forget to renew your license. And y'all know what my BIC said to us yesterday in our sales meeting? Don't forget to renew your license. You know what our question to him should have been? Did you do yours? Because if the BIC doesn't renew, then we're still in that same situation. Does that make sense? So everybody's got to renew. Again, talking more about that. Just started yesterday. Still on general brokerage provisions. I hope we're good with this. We are not attorneys. We cannot draft. Guys, why do we keep harping on this? Because the consumers will ask. I'm a heck of a lot cheaper than an attorney. And they're going to say something like, can't you just add this? Can't you just delete that? And our answer to them is no, because I'm not an attorney. Even if their instruction, remember, I follow my clients' lawful instructions. The only thing we're allowed to do is fill in the blanks of the pre-printed forms that were provided to us. Most of the pre-printed forms we use will come from the North Carolina Association of Realtors, if you're a realtor. But I think it's really important that we understand, always remember, we are free to use any pre-printed contract, any pre-printed form, as long as it was drafted by an attorney. Some firms, some builders have their own sales contracts, and that's fine. They can use those. As long as it was drafted by an attorney and it meets minimum requirements of Commission Rule 58A.0112. You don't need to know that. I just put it there for reference. And if you're ever going to be using a pre-printed form, we need to make sure that it is in compliance. A non-NCAR form, we need to make sure that it's in compliance with Commission Rule 58A.0112. Questions? Another general brokerage provision, we introduced this idea to you the other day. We're going to say a little bit more about it. We all know we have to have a background check done to get our license. But once we're licensed, we're not off the hook. Should we get ourselves in trouble, either with the courts or with your other occupational licensing board, your other professional licensing board? We're going to talk more about those in just a second. But if you get yourselves in trouble, we must notify the commission of the conviction or the disciplinary action within 60 days of the conviction or 60 days of the disciplinary action. What is the real estate commission going to do to you if you get a conviction or if you get disciplinary action from your other professional license? I don't have the answer to that. Remember, they review everything on a case by case. Our job is to report it. This is what I do know. Failure to report it is a violation of commission rule. I don't know what kind of household you guys were raised in, but in my house, when I did something bad, it was much better that I told mama about it instead of letting mama find out about it. Anybody else? Fess up. Let's think of the commission like mama. It's best to tell them than to let them find out on their own. If they find out on their own, you have violated a commission rule in addition to whatever your conviction or disciplinary action with. Does that make sense? This pops up in the disciplinary action every once in a while. Fail to report a conviction. How do they find out? I have no idea. But once they find out, now it's a problem. So let's break down these bullet points. If you've been convicted of a felony or misdemeanor, you need to report that. I need you guys to note the word convicted. If you've been charged with a felony or misdemeanor, then you've not been convicted. If you've been charged, it means you got pulled over, you got the ticket, you got cited. Convicted means the gavel came down and the judge said guilty. So if you get charged, you don't have to report that. You only report it when you've been convicted. Felony or a misdemeanor. And then your disciplinary action from another professional licensing board. This tends to be a problem topic. Not all of you have another professional license. Does anybody have another professional license? CPA, CNA, cosmetology, maybe some others out there. You may also, this also refers to having a real estate license in another state. So let's say you live in Charlotte and you're right there on the border, and you decide, now that you're about licensed in North Carolina, you decide that it makes good sense to also get your license in South Carolina. South Carolina rules and laws are different than North Carolina rules and laws. And you got the task of asking yourself on the regular, what state am I dealing with? Because those are the rules that you follow, whatever state the property's in. Should you get yourself in trouble with the South Carolina Real Estate Commission, you've got to report that to the North Carolina Real Estate Commission. That disciplinary action from another licensing board. Another professional license, you've got to report it. Questions on this? In Unit 8, we talked about our Residential Property and Owners Association disclosure statement and our mineral and oil and gas rates, also known as our RPODs and our MOG. Both covered under the Residential Property and Owners Association disclosure. So we have an act that covers both. Remember, you guys, both of these forms, Unit 8, these are seller disclosures. So let me see your mouths move. Who is responsible for completing these forms? The seller. Can I do it for them? Sometimes it's easier to just grab the pen and say, oh my God, let me do this. Can I do it for them? No, this is a seller disclosure. These are seller disclosures. I can assist, I can help, I can answer questions, but I can't do it for them. They are the ones that have to complete it. Should the seller fail to provide any of the seller disclosures, that could allow an out for the buyer. They could have up to 3 days after contract formation or receipt, whichever one happens first, to terminate their contract. Understand, they're terminating for failure to receive. They're not terminating because they don't like how it was filled in. They can't terminate because the seller said no representation, for example. North Carolina is a caveat emptor state. The seller has every right in the world to say no representation. That's what makes these forms just so interesting. Mandatory disclosure, which means they got to provide it. Mandatory form, which means they have to provide it with an optional disclosure. By the way, just to prepare you guys, they have released a new RPODs. We're starting to use it. My firm's going to start using it. We talked about it yesterday in our meeting, and my firm's going to start using it at the end of the week. I tell this to you guys because all brokers, all firms have to start using it by July 1st. So there's a really good chance when you guys affiliate, the RPODs that I showed you a couple weeks ago is going to look a little bit different than the new RPODs. I will say across the state, it's such an improvement. So you can have that to look forward to. But just be prepared for that because you guys are coming in right at that. So you affiliate your firm, your BIC says, here's the new RPOs. Well, that's not what I saw in pre-licensing because we got a new one. It got a great response from my firm yesterday. So we're very, very, very excited. It looks nice. It's easier to understand. It's easier for the consumer to understand. It's easier for us to explain. They increased the font. You guys hadn't seen the original yet, but I swear they use like font 8 or 6. It was like this big. And they like 10 now where you can see it without a magnifying glass. Exciting changes. So just so you guys tuck that in the back of your head, you're going to be coming into a new form, but your BIC will assist you. The other thing about the RPOs and the MOG, these things need to be kept current during the listing period. What I mean by that, if your seller says, no, this isn't broke, and then it breaks, we need to update the RPOs. If your seller says, yeah, this is broke, and then they fix it, we need to update the RPOs. That thing has got to be kept current throughout the listing. So as any property status changes, we need to make sure that we're getting with our seller and having them provide a new one. In Unit 21, we talked about our closing disclosures, specifically our responsibility for these closing disclosures. Closing documents are an instrument So we have a duty to make sure within how many days of closing did they get a copy of this? 3, yep. So we have a duty to ensure. I'm probably not delivering them. The truth is the attorney is probably providing them to them. But what does that say? My duty is to ensure. I have a duty to make sure that they got it. Our other big responsibility is reviewing that closing disclosure for accuracy. You guys now know how to prorate taxes. You guys now know how to do interim interest. You know what's a debit to the buyer, credit to the seller. You'll get more in post licensing. We're going to do a full-blown settlement statement post licensing. We got to review it for accuracy. And when we find a mistake, when we find an error, we have a duty to report that to the closing attorney so they can get it fixed. Questions? General brokerage duties. Moving right along, the next piece in our contract, in our comments, we are finally going to address and specifically talk about that trust account, also known as an escrow account. The basic definition of an escrow account: it's an account that has somebody else's money. Your money, the firm's money, the broker's money, the client's money does not belong in the trust account. Well, the client's money. Your money does not belong in the trust account. The basic definition: it's an account that has somebody else's money. Why don't you guys set your chats to private? And in a private chat, you can abbreviate, I know what you speak of. In a private chat, tell me what are some examples of other people's money that we would hold in a trust account. And think before you type. Who is holding that money? Who gets that money? And what are some examples of other people's money that we would hold in the trust account? Let's see what we got here. I've only heard from like 6 of you, so give me a minute. So what are some examples of money that would be in the trust account? Other people's money that be in the trust account. Earnest money deposit. The earnest money deposit is hanging out in an escrow account. That impartial third party is hanging on to the earnest money for the transaction. Several of you said due diligence. That's not right. Due diligence doesn't go in an escrow account. Where does due diligence go? To the seller. The buyer pays the seller the due diligence fee directly. It's not held anywhere. The buyer pays the seller. So earnest money goes in the trust account. If it's an option to purchase, unit 10, the option fee may go in a trust account. Property managers, your security deposit goes in a trust account. You may run rent through the trust account and use that to pay others That's the key. That's the trick. It's somebody else's money. Firms and closing attorneys that have an escrow account also have an operating account. The operating account is where you deposit your commission checks and you pay your agents and you pay your power bill. So they're going to have two accounts, one for their money to receive and pay out, the other for other people's monies, for example, earnest money. Questions so far? Or we dig a little deeper on the trust account. So, some primary features, some things to know about the trust account. It's separate, which means it's not your operating account. It's a separate account from your operating account. Again, it only contains money belonging to others. It's custodial, meaning who has access to it is limited. If your money's in the trust account, if you're a buyer or seller, you shouldn't have access to the trust account. That's that impartial third party. The broker in charge is ultimately responsible for if the firm has it, real estate firm has it. The broker in charge is ultimately responsible for the trust account. They may have staff manage it. It could be an unlicensed employee that manages the trust account. But ultimately, the broker in charge is responsible for it, and it's limited to who has access to it. The other thing about the trust account is those monies are available on demand. Because remember, all we're doing is holding on behalf of parties. You can't spend that money. Let's say your firm has a really bad week and all of your buyers terminate this week. All of them. That's a bad week, isn't it? We can't say, ooh, let me get money and then I'll refund your earnest money deposit. Available on demand means if the buyer terminates today, we need to be able to release them their earnest money, or the seller the earnest money today. So it's a demand deposit account, like we just said. It's got to be in a bank, this FDIC. You see that on the sticker on the front door when you walk in the bank. Not all banks are FDIC. Credit unions, for example, are not FDIC. So trust accounts got to be an FDIC. The bank itself has to lawfully be doing business in North Carolina. They don't necessarily need to be located in North Carolina, but they need to lawfully be doing business in North Carolina. And then the escrow agent and the bank agree to make their records available to the North Carolina Real Estate Commission. They could walk in the door of the real estate firm at any time and say, show me your trust account, show me your books. And in which case we need to turn those records and reports over to allow them to inspect it. They could also approach the bank as well. The actual words, trust account or escrow account, have to be on all the documentations and the records. So any signature cards, deposit tickets, checks, ledgers, statements actually have to say trust account or escrow account. We got to identify that that's what the account is. The reason being for this is because we don't want to freeze the funds if something happens to the BIC or the firm. Imagine for a second if you were a broker in charge and you were a one-man show and it was just you, and that one-man show passes away. We don't want that account to be frozen by their estate. Once the estate starts digging in, we want them to see that it's a trust account, and that'll alert them that it's somebody else's money. Now, the requirement is that we have accurate records to identify who the parties are. Who's the buyer and seller that we're holding this earnest money deposit for? What's the property address? Who's the lessor and lessee that we're holding the security deposit for? So we need accurate records. Generally speaking, firms are only required to have one trust account. You may have firms that do both for sale and for lease. They have earnest money deposit and security deposits. They only have to have one trust account. They could choose to do two, one for the earnest money, one for the security, but the only requirement is that they have one. The exception to this rule is if the property management company is managing HOAs. Each HOA gets their own trust account. So if your property management company has 5 HOAs, you got 5 trust accounts. I'm going to say, hands down, without a doubt, the number one violation or disciplinary action of the trust account is commingling. Commingling is having your money in the trust account or having somebody else's money in the operating account. We can't commingle. We can't cross those funds. And I think sometimes, you guys, I don't think people are malicious. I think sometimes it's as innocent as, I just got notice today that if I don't pay my power bill, they're going to cut my power. I get paid tomorrow. So let me just go ahead and borrow money from the trust account today. And as soon as I get paid tomorrow, I'll transfer that money from my operating account to my trust account. Is that okay to do so you can keep your power on this evening? No, you cannot commingle. You cannot share those funds. The exception to this rule, if the bank charges a monthly fee and they're going to do an automatic draft for that monthly fee, you can have up to $100 of your own money in the trust account for that monthly fee. And when that deplenishes, you can build it back up. 100 is the max you can have at a time. That is only to cover banking fees. Trust accounts can be interest-bearing accounts. The escrow agent just has to let the parties know. It's maybe in an interest-bearing account. The interest collected then would belong to the escrow agent. And when you collect that interest, you need to transfer your earnings from the trust account to your operating account. As I said, the broker in charge is responsible for the trust account. They can have employees manage it. They can have unlicensed employees manage it. But ultimately speaking, they're the ones responsible. So if the real estate commission walks in the front door and says, show us your trust account, they're talking to the BIC. They're not talking to the one that manages it. Back in my unlicensed employee days, I managed the trust account. And I reported to my BIC about the trust account monthly. We sat down once a month after I reconciled it. We sat down, he signed off on it. He was very involved because he understood he was responsible for it. Records got to be current and accurate. They don't necessarily specify what current means, but I always ran under the rule of thumb. You got a bank statement once a month, right? So when the mail came in, sit down and make sure that thing balanced out. And then accurate, having your records, whose money is it, what are we holding it for, etc. The Real Estate Commission has a trust account class, a trust account course. If you are going to be managing or maintaining your own trust account, opening your own trust account one day somewhere down the road, you got to take the class. They do require you to take the class. It's online now. If the real estate firm has the earnest money, real estate firm has the trust account, real estate firm has the earnest money. At some point before settlement, we got to get those funds to the closing attorney's office. The closing attorney has to have all the money accountable for so they can pay out the proceeds of the sale. So at some point, real estate firms have to get that earnest money from their escrow account to the closing attorneys. Commission rule addresses disbursement. We cannot disperse. We cannot send that to the settlement agent no more than 10 days prior to settlement. If you affiliate with a real estate firm that has a trust account, they will go over their policies with you. They will tell you how they want you to proceed. I had a clipboard outside my office, so agents came and signed up for monies when they need it. That's a great question, Debbie. I don't know the answer to that. It could easily, I could imagine. We know how earnest money works. If the buyer terminates within due diligence, they get their earnest money back. If the buyer terminates after due diligence, now the seller gets the earnest money. Bear with me. If we terminate either inside or outside of due diligence, the parties have to agree to release the earnest money. It's not released automatically. The parties have to agree to release, and we have forms for that, where the parties agree to release their earnest money. If either party doesn't agree, then the earnest money is in dispute. The escrow agent is an impartial third party. The escrow agent, even if they're an attorney, they cannot release the earnest money deposit unless we have written consent by both parties. And if both parties aren't signing, we have disputed funds. The escrow agent can make several attempts to reach out to both parties to try to get them to release it. Send a certified letter or something so you have your documentation that you try to reach out to them. But bottom line, after X amount of time, if this money is still in dispute, then the escrow agent turns it over to the clerk of courts and lets the two go downtown and hash it out. The contract is very, very clear about what happens to the earnest money if we terminate. And the clerk of courts will look at the contract and say, well, it says right here who should get the money. I don't understand what the dispute is. And they'll release the funds according to the terms of the contract. These are stubborn people digging their heels in, y'all. You think they're out there? Oh, yeah. What we need to understand is that the escrow agent can't make a decision about what happens to the earnest money because it's not their money. All they're doing is holding it. And like I said, this applies to the closing attorney as well. They are perfectly capable of interpreting that contract, but they are still acting as the impartial third party. Escrow agents, once you receive that earnest money, once it's in your hand, escrow agents have 3 banking days from receipt or contract formation to deposit the earnest money, get it in the bank. 3 banking days of receipt. So this would be probably the typical scenario that we deal with on the regular. We negotiated an offer, buyer and seller have agreed, communication of acceptance has happened. Congratulations, we're under contract. Buyer's agents, we go pick up the earnest money deposit check from our buyers, deliver it to the escrow agent. The escrow agent has 3 days, banking days to deposit it. Probably what happens most often. Contract formation. This would be a scenario. The buyer may hand you their earnest money deposit while we're still negotiating. A contract has not been formed. Maybe they're out of town and they're getting ready to get on a plane. You've been showing a property all week and they're getting ready to get on a plane and they want you to have that earnest money deposit. So when their contract gets accepted, you'll have it to deliver it, right? Your firm may or may not have a policy on that, but generally speaking, if we have the earnest money in our possession before the contract is formed, the buyer doesn't owe anything until I have contract formation. So if they hand you that check, I'm not going to put it in the bank. We're going to turn it over to our BIC for safekeeping. A contract is formed, get it to the escrow agent. Now they have 3 days to get it in. Contract formation. What if the contract's not formed? What if that offer's never accepted? Then we dispose of that earnest money check in accordance to our buyer's instructions. Do they want you to write void on it? Do they want you to take a video of your phone while you're shredding it, right? How do they want you to destroy their check if the contract is never formed? So 3 banking days within receipt or contract formation. The exception to this rule, don't we love good rules with exceptions? The exception to this rule is cash. If they hand you an earnest money deposit in cash while we're in the throes of negotiations, get it in the bank. Cash is dangerous. We don't want cash laying around. We don't want a lot of hands touching cash. Cash likes to walk away pretty easily. So if they ever hand you cash, get it to your BIC. Your BIC can put that in the account while we're still negotiating because cash is readily available funds. So as soon as we put that in the bank, we can immediately write a check back out to the buyer if that contract's never put. Does that make sense? Cash is the exception. And like I said, your firm may have a policy that says, yeah, no, it's 2024. We're not dealing with cash. The other thing I want to mention, let's go to real world just for 1 second, because this is what's going on in the real world with this. This is another thing that we got everybody got an email from the commission. It must have been late last year. I think brokers mean well. I know brokers mean well. And sometimes we're looking for a solution to an answer. We always need to remember license law and commission law. There was a rash last year, evidently, because who has checks anymore, right? Nobody has checks. And evidently last year, the answer to the solution, well, I don't have a check. How can I get this due diligence fee, for example, to the buyer? I'm sorry, the seller. Agents were allowing buyers to send that money to them via Cash App. And then they were writing a check from their account to the sellers. I see head shaking no, and that does my heart really good. It sounds helpful, doesn't it? It sounds like a creative solution. It also sounds like a violation of commission rule, because commission rule says if you're going to receive or hold somebody else's money, you got to have a trust account. Cash App is not the creative solution. You guys are caught up with the rest of us now. Pre-licensing hat back on. Does that make sense? We got to always remember the rules, you guys. So what do? Sorry, buyer, you got to go get me a cashier's check. Or maybe you and the seller can agree to do the seller's Cash App, right? We got to come up with another solution. You guys, my soon-to-be provisional brokers, cannot walk around with somebody else's money. Provisional brokers, if you're ever handed money, just hang on to this for me while we're negotiating. You got to get it to your BIC immediately. Provisional brokers cannot walk around with somebody else's money. Full brokers should not walk around with somebody else's money. Bottom line, if you have somebody else's money in your hand, you're responsible for it. My suggestion to you is to get it to where it needs to go. If we have somebody else's money in our hands, PB, full broker, BIC, anybody, it should just be for the purpose of delivery. It should just be for the purpose to get it from this person to this person. Trust funds have a specific dealing with auction money or the due diligence fee. Again, I'm acting as delivery man only. So I can help deliver. I can assist the buyer, pick the check up, deliver it to the seller, the listing agent, deliver the seller. Get it to where it needs to go. Don't hang on to it for 3 days, but commission will give us 3 days to deliver. That's 3 days of a lot of responsibility, isn't it? Get it to where it needs to go. The other piece specifically about the due diligence fee. Remember, I'm just acting as delivery man. So let's say, for example, your buyer goes under contract and you meet your buyer in the parking lot somewhere and you pick up the checks, earnest money and due diligence, and you're en route to deliver them. You're en route to deliver them to the listing firm escrow agent. And your buyer calls you and says, don't deliver that. We've got to follow their instructions. It's not my money. I don't get to make decisions about what happens to it. Now I can say, really, are you sure? And if we don't deliver it, it could give the seller an out. It could give the seller the opportunity to terminate. But bottom line, if they say, do not deliver it, I've got to follow their instructions. Once you've delivered it, it's out of your hands. When it's out of your hands, it's out of your control. Everybody has a responsibility for safeguarding somebody else's money. I don't care if your firm has a trust account or not. What's the A and O car? See mouse move. What's the A and O car? Accounting. That's dealing with somebody else's money, helping them account, safeguard, accuracy, etc. Questions on the trust account? Okay. Let's take 10. We'll come back, more on the comments. Welcome back. So I'm going to take attendance. We're about ready to wrap this up. The last thing we have to say specifically in the comments section is one quick refresher on BPOs and CMAs. BPOs and CMAs, not everything follows license law and commission rule. Some get license law or commission rule. The BPO CMA is one of those fun things that deal with both. So there's lots of rules and regulations involved in BPOs and CMAs. Unit 17, you guys, soon to be you guys, cannot do these things for a fee. You can do it, but you can't do it for a fee. None of us can charge a fee when it's part of our general brokerage duty. So when we're at the listing appointment and the seller says, what do you think I should list my house for? Well, here we go. Cash at me $200 and I'll let you know. Does that sound right? That's just part of my job, y'all. Same thing when the buyer says, this is my dream home, let's write it up. The next question out of their mouth is going to be, how much should I offer? In which case, we're not going to charge them that fee. That's just part of our job. So if we are charging a fee, it's an outside third party, like maybe a relocation company, for example. None of us get to do this to determine value. Who gets to use the word value? I can see mouths move. Who gets to say the word value? Appraisers. So we're not determining value. We're not saying the word value. And we're certainly not determining these to originate a loan. That's what we have the appraiser. So if I can't say value, what can I say? Words matter, y'all. I say probable sales price or probable lease price. If you're performing these things for a fee, you got to be in compliance with license law and commission rule. You're going to spend more time with these in post licensing. First couple of these you should be doing with help. Get on any training for CMAs you can. Your local board of realtors might offer training every couple months or quarterly or something. Take advantage of it. Take advantage of things that are offered from your local board of realtors. I hear brokers run around all the time. All these fees, all these dues. Well, how are you taking advantage of it? They got legal helplines and training classes, and you're not just sinking money into them unless you're not taking advantage of them. They do a Christmas party once a year. Go get your two free drink tickets. They're not free. You paid for them. Take advantage of what they have to offer. It's part of your dues. Put your hand down. Dues vary from local board of realtors to local board of realtors. Your broker in charge will get with you about the dues and the fees when you get to that point. How many of you are going to like back? You're not going to be tested on dues. And they got to be in writing. And of course, now we know that we're going to document. So anytime you run one of these things for buyers or sellers, keep it, document it. And this is something else that maybe need to be done periodically throughout the listing period. So if I list the seller's home today, we're going to do a CMA. 4 months from now, if we haven't sold yet and we're revisiting it with the seller, they call it a price improvement these days. I'm going to want to do a new CMA in 4 months because it's going to be different than what we did today. So anytime we talk price specifically with the seller, we want to do an updated CMA. And of course, we want to keep that. And that gets us through our comments. It is. The comments are the biggest section of your state specific section. Other sections are scattered all throughout this book in this class. When we talk about NNC specifically, that is a candidate for a state specific test question. The rest of what I'm going to talk about is found in license law or commission rule. I don't have page numbers because we don't need to reference anything, but we do need to go over it. It is testable stuff, and it's also good for like real life too. So managing your license, renewing it every year, stuff like that. We may see it on the test, but we also need to know for the real world how to maintain that license. So I'm going off any book or resource that's in license law or commission rule. And to continue, they address proof of licensure. When you're licensed, you'll get a nice 8.5 by 11 in the mail. We've talked about that yesterday. Go ahead and frame it. Additionally, every year that we renew, they will issue you a new pocket card. I will talk about the renewal process in just a second. So they'll issue a new pocket card. You're looking at a picture of mine right now. Pocket cards got to be kept on us while we're performing brokerage duties. You can cut it out and actually put it in your wallet, or they have a digital version now where you can carry it on your phone. Or if you're kind of a nerd like me, I have both. I'm prepared because I think it's safe to say I'll always have my wallet or my phone on me, right? So I'm ready to any means. So whenever we're engaging in brokerage activities, working with buyers and sellers, doing an open house, attending a CE class, all of those are brokerage activities, and our pocket cards need to be on us at all times. These pocket cards renew every year. Again, more on the renewal period in just a second. Additionally, the firm has a license. The firm has an 8.5 by 11 license. The firm has to display their license. The individual broker does not, but the firm has to display their license as proof of licensure. License law and or commission rule addresses that disclosure of offers are prohibited. We cannot disclose the terms of an offer without the offeror's permission. Who is the offeror? Do not say buyer or seller. Who is the offeror? The giver of the offer, the creator of the offer, the person who offers, the person that's making the offer. We cannot disclose the terms of the offer without their permission. Listing agents. You may find yourself in a multiple offer situation. You got a hot little listing and it's going fast and you got offers coming in left and right. There's a really good chance at some point you're going to get a phone call from another agent that says, what is the highest priced offer you have in your hand right now? Think before you answer. Can you answer that question? Not without permission of the person that gave you the highest priced offer. Is anybody in their right mind going to give you that permission? Is anybody going to say, oh yeah, tell them what I offer to give them the chance to beat it? No. There's no rule that says they can't call and ask you. The rule addresses how we respond. Be prepared for this, you guys. And your response needs to be, I cannot disclose that. Advise your buyer to submit their best and final offer, and we will consider it along with all the others. Did I tip the hat in any way? I told them to bring me their best, and we'll look at all of them. We cannot disclose the terms. The second piece of this, buyer's agents. Say you're working with two different buyers. And guess what? Both buyers become interested in the same property. Remember, you guys, I'm a fact finder. Am I telling anybody what to offer? I'm providing both the same information. What I do for one, I do for all. So I'm going to do one CMA for both. I'm going to let them come up with the numbers that they're comfortable with. I can advise them, but I'm certainly not going to pit them against each other. I know what both buyers are offering because I'm working with both of them, but it's not like I can say, well, I know the Smiths are offering this and the Jones are putting this much due diligence up. I can't shop offers. I can't pit the people against each other. We cannot disclose the terms of the offer without the offeror's permission. Makes sense, doesn't it? Questions on that? Okay, license renewal. Every single year, we have to, that you want to practice, we have to renew our licenses. And before we see too much, let's talk about the Real Estate Commission. And let's talk about the fact that the Real Estate Commission does not operate on a calendar year. The Real Estate Commission operates on a physical year. And the Real Estate Commission's physical year is over on June 30th. July 1st starts their new year. Every single one of our licenses, PB, broker, BIC, firm, limited, non-resident, commercial broker, every single license expires at 11:59 p.m. on June 30th unless we renew. In order to renew, when I say renew, how you renew your license is by showing them the money. Every year to renew, we have to pay a renewal fee. The renewal period kicked off yesterday. They're already all over Facebook, email. They're letting us know. The renewal period every year runs from May 15th to June 30th. We have 45 days to renew our license. The renewal fee this year and last year and the year before, and I can't remember how far back, the renewal fee for as far back as I can remember has been $45. Is that subject to change? Of course, but there are laws in place on how much it can increase a year. So if we ever do see an increase, it's not going to be like heart shocking. So if this is easy to remember for you guys, we have 45 days to pay $45. When you renew, when you send in your fee, your license beginning on July 1st will be current. I'm going to talk more about current license in just a second. If I may make a play on words to help us see this a little bit better. When you guys see the word current, what I would actually like you to see is currency. Your license is current because you pay the renewal fee. Your license is current because you showed them the money. A current license has nothing to do with education. A current license is only current because you paid the renewal fee anywhere between May 15th and 11:59 p.m. on June 30th. You can go online and pay it. They make it really easy now. If you don't pay the fee on the stroke of midnight, July 1st, your license is expired. So the first step in understanding our licenses is current versus expired. A current license has everything to do with the money. It has nothing to do with education. So a current license is because you show them the money somewhere during the renewal period. I will talk in just a second about what happens if your license goes expired, how you can get that back. But for right now, if we could, let's just stay on this idea of current. A current license, where can I put this? I'm running out of room. A current license can be one of two things. A current license, can you guys still see this okay down here at the bottom? Okay. A current license can be either active, active, or a current license can be inactive. Why is it current? Because you paid the fee. So what happens to a current license once you pay that fee? Take it a step further. A current license can be active once you are up to date on your education. Full brokers, we have to do CE every year. I'm going to talk more about CE in just 1 second. Full brokers, we have to do CE. In addition to paying the fee makes us current. So full brokers, how do we make a current license active? Do CE. We'll talk about CE in a second. A current license can also be inactive. It's current because you paid the fee. It's inactive because we may have an issue with your education. So an inactive license is current, but it's inactive because either you're PB without a BIC, you didn't do your CE on time, you didn't do your post licensing on time, or by choice. Maybe you come to a point in your real estate career, you come to a fork in the road of life, and you have a decision to make if real estate is on that path. Maybe you're starting a new family. Maybe your parents need care. Who knows? But we come to forks and roads of life, yes, and we have decisions to make. And sometimes we may think that real estate needs to take a back burner, and maybe it does. You could choose to ride for the rest of your life on an inactive license. All you have to do is show them the money every year. Pay your $45 in every year, and you can ride for the rest of your life. Now I'm getting some questions like, why in the hell would I do that? I got a solution. I got an answer for you in just a second. Bear with me. So maybe you're done with real estate. You wake up one day and you say, yeah, no, I don't want to do this anymore. Rest of your life, by choice, you could go inactive. The only thing you have to do inactive to stay inactive is pay the fee. Keep that current license. Once your license goes inactive, if your license goes inactive, the question is, what do you do when you want to reinstate? Maybe you come back to another fork in the road of life. You're like, ooh, I'm ready to get back into real estate. I've had an inactive license for 2 years, 20 years, whatever. I'm ready to get back in it. What do I do? Well, if you've been inactive with no CE deficiency, you can still take CE on an inactive license. So let's say you choose to pay the fee and keep up with CE. You don't have a CE deficiency, which means all you got to do is submit the form and poof, you're active again. You're up to date on your money. That's how you stayed inactive. That's how you stay current. And now you're also up to date on your education. If you've been inactive for less than 2 years and you have a CE deficiency, maybe you have not done CE in the last 2 years, but you've paid the fee, so you've maintained your inactive status. You got to do this year's CE. There's 2 CEs we have to take, an update and elective. Again, I'll talk more about that in a second. And then they make you do an extra or 1 or 2 extra electives. Question comes in, what can I do on an inactive status? You could say, I used to have a license. The only thing we can do is with an active. You got to be active to do anything, to get paid, broker services, etc. So inactive for less than 2 years, and you haven't been doing CE again, you can still do CE on an inactive license. If I may recommend, if you go inactive for a period of time, consider doing CE every other year. And that'll keep you within this criteria. So you just got to do this year's CE, and then they may, depending on how long, if it's right at 2 years, they may make you do an extra elective. It was just last month. They may say, okay, you're all right. If you've been active for more than 2 years with a CE deficiency, more than 2 years inactive, and you've not been taking CE, you got to do this year's CE. And then you got to go back and retake 2 of the 3 post-licensing classes. That includes passing the exams. See why I say at least every other year take CE? Trying to keep you out of post-licensing again. The 2 of your choosing, so there's that. You can pick your 2 favorite and just go back and redo those. The thinking is, guys, if you've missed more than 2 years, there's a lot change. There's a lot that happens in real estate. So they want to send you back to post to make sure that you're current. So reinstating an inactive license, you have been paying the fee. Your license is current, but now we just got to get you up to date on your education. The other piece of that is you guys, provisional brokers. You guys have 18 months to finish post-licensing from the date of licensure. The question comes up, what if I don't do all 3 posts in 18 months? And the answer is your license will be inactive until you get it done. Even if you're in the throes of a real estate transaction. Don't let that 18-month get away from you. And if you start working with buyers and sellers, it's easy to do. It's only a year and a half. Watch your clock. If you miss that 18-month, you will be inactive until you get it done. Questions on an inactive license? Failure to pay the fee means that your license is expired. I don't care if you did CE or not. I don't care if you did post licensing or not. Step 1, pay the fee. Step 2, figure out education. So if your license is expired, it's because you failed to pay the fee. So how do you reinstate an expired license? And the answer is, how long were you expired? If you were expired less than 6 months, you wake up on July 1st and go, are you kidding me? I forgot to pay the fee. What do? You pay the renewal fee of $45. You pay a reinstatement fee of $45. $90 later on July 1st, and poof, you're back active, assuming your education's up to date. So less than 6 months, you pay 2 times the amount of the fee, and poof, you're back active, back in business. If your license is expired 6 months to 2 years, you pay those 2 fees, $90. Then you have a choice. You can either come back and take the post-licensing class of your state, of your choice, or you can go back to Pearson VUE Testing Center and sit for the state exam again. Probably going to do post, aren't we? We got to get you some education. You've been expired 6 months to 2 years, which means you haven't paid the fee. 6 months to 2 years. Get caught up on the fees and get caught up on the education. What if you're expired for more than 2 years? Everybody kind of brace yourself just a little bit. So everybody ready? Expired more than 2 years, you get to start all over from day 1 of pre-licensing. You got to pass the end of class exam. You got to go back to Pearson VUE Testing Center. You got to take all 3 post-licensings. See why I want you to pay the $45 every year and ride for the rest of your life on an inactive license? Failure to pay the fee. And guys, this happens so much. We think we're done with real estate. And then 7 years from now, we wake up and go, ooh, I used to have a license. I want to do that again. And you call the commission, you know what they say? Find you a good pre-licensing school because you're starting all over. Is it worth it to pay the $45 every year? I can't really answer that question for you. The last in-person class I taught before we shut down, I had two that were there on an expired license. I said, y'all learned your lesson? Oh yeah. Guess what? I still see them around. They are keeping that license. They are not letting it go again. You got it once. You worked hard to get it once. Keep it. There is an exception. I'll talk about that in a second. I'm getting to CE. Current versus expired is all about the money. I feel the need to say this again. A current license has everything to do with money. It has nothing to do with education. The education kicks in. The current license can be active or inactive. So we get it. We're going to keep it. That's kind of the general based on your facial expressions. 45 bucks. Unless you know you're done. You guys, we've said this. We're good. You don't need to write this down. Provisional brokers, you can do just about everything that a full broker can do. The key is the trick. You got to be supervised by a broker in charge. You got to be affiliated with a firm. Provisional brokers, you are inactive until you affiliate. Once you affiliate, that's the only way to activate your license. PBs, you guys can do just about everything that a full broker can do. There are a few exceptions. You guys cannot charge a fee to do a BPO or CMA. You guys cannot hang on to somebody else's earnest money. You can't walk around with somebody else's money. And you guys cannot be designated opposite of your broker in charge. Otherwise, you can do just about everything that a full broker can do. You can work with buyers and sellers and landlords and tenants as long as you're supervised by a BIC, you're affiliated with a firm. Anytime we're sending fees in, renewal fees, application fees, make sure you got the funds when you put in that credit card. Don't let it bounce. Return fees could be considered. I don't know what they'll do, but it could be considered. So before you pay your dues, before you guys submit your application, make sure you got the funds in the account. There's a whole section about CE. You don't need to know the section number. I just have it there for reference. We only have to do 2 4-hour CEs every year. So we do 8 hours of CE each year. The deadline to do CE every single year is June 10th. June 10th, June 10th, June 10th. Every single year. There is a blackout period on CE classes from June 11th to June 30th. Nobody can offer CE class for CE credit between June 11th and June 30th. The last bulletin we got, we've been hovering around 100,000 licensees right now in the state of North Carolina. All licensees have to renew between May 15th and June 30th. Firms have to renew. Education providers have to renew. Instructors have to renew. There's a lot going on in that 45 days, isn't it? There's only like 60 some people that work at the Real Estate Commission. They got a lot going on. They've officially entered their busy season. They've got to cut June 10th off, CE off at some point, so they have time to process all these renewal fees, time to process all the CE credit. CE in schools ramps back up August or so. August or September is when we start seeing offerings for CE again. So you pretty much have from August to September until June 10th to take CE. They give us plenty of time. They give us the majority of the year. If you want to wait until the very last minute, things happen, you guys. I've heard horror stories of things that have gone wrong on people that wanted to wait until June 10th. What if you're taking your CE on June 10th via Zoom and you wake up that morning and Spectrum's out, you don't have internet? What if you're going to go in person and you wake up that morning and you have a flat tire? There are no exceptions to this June 10th. Did everybody hear what I just said? There are not exceptions. If you call the commission and say, oh, but I had a flat tire, they're gonna be like, you've had since August. Why are you waiting until June 10th? Please, please, please don't wait until June 10th. This is the voice of experience begging you guys. Back in my admin days, I was kind of the lane of a real estate school, and I hated going to work on June 11th because my phone was blowing up. I forgot to do CE. What do I do? So what happens? As long as you pay the fee, always pay the fee first. As long as you pay the fee, if you forget to do CE or you don't do CE, on July 1st, your license will be inactive until you can get caught up on your CE. So at least you have a little wiggle room here to try to get it closed or whatever. That's right. So failure to do CE by June 10th, you got a couple days, but on July 1st, assuming you pay the fee, your status is active. I'm sorry, your status is inactive. The two CEs that we do every year, they break them down into 2 4-hour classes. So there's a 4-hour update course. The update course is the commission's opportunity to send the same information out to all licensees. There's 2 update courses. There's a general update for PBs and brokers. There's a BIC update, a broker in charge update for BIC eligible and designated broker in charge. Take your appropriate update depending on your status. The other CE we do every year is a 4-hour elective. This is a topic of your choosing. There's so many topics out there. And I kind of like the idea, if you have a niche or if you have something you want to learn more about, find the topic and knock out your CE. 2 birds, 1 stone, right? So if you want to learn more about green housing, you can take a CE class for that. I venture out there to say, think of a topic. Just think of a topic. Agency, contracts, green housing, mold, what else? It's safe to say there's a CE elective out there. So you can search around for the electives, find one that can not only satisfy your CE criteria, but also help your career, help benefit your career, give you information. All CE classes offered around the state are available on the commission's website. So you can search by topic, location, Zoom, in person, right? You can choose that elective and get it done. So how do we have an active license from year after year after year? Pay the fee and do your CE. See how that rhymes and everything? Pay the fee and do your CE. You guys want some good news? You guys, your first renewal period, the first time you hit June 30th, you don't have to do CE that year. You get your first year off of CE. Yay! You don't have to start doing CE until your second renewal period. So the day you get your license, stop and draw yourself a timeline. The first time you hit June 10th, you don't have to do CE. The second time you hit June 10th, you got to do CE by then. The thinking is you just got out of pre, you're in the throes of post, you're getting the knowledge. You're getting the information. So the question come in, I guess they make us take us every year after your second year and every year that you want an active license. So mark your calendars. June 10th, CE deadline, every single year. They may grant an extension for a hardship, but it's only for a hardship. For example, the year of the pandemic, they deemed that a hardship. You're not going to be able to call the commission on June 9th and say, I got busy and I forgot. That's not a hardship. Active military deployment may be considered a hardship. CE deadline is June 10th. The renewal period deadline is June 30th. There is usually about this time of year, we're going to get a letter from the real estate commission for you guys that may be testing during the renewal period. And it's like, if you get your license during this time, this is what you do. If you get your license, but you guys may be testing during the renewal period. As soon as we get it, we'll put it in the online learning system for you guys to look at. We'll put it in the welcome section of the online system, of the online learning system, so you guys can have access to that. So the letter will address that if you're going during that time. CE and post licensing are not the same thing. CE is CE, post licensing is post licensing. Post licensing is for newly licensees. It's an extension of pre. It's digging into some of these bigger topics that we covered in pre. CE is for all licensees across the state of North Carolina. You don't get post licensing credit for CE. You don't get CE credit for post licensing. They are two separate things. They're two different departments down at the commission. So post licensing, 3 30-hour class hours, 301, 302, 303. You can take them in any order you want. Just take them, finish them up within 18 months of your initial licensure. Again, when you get your license in the mail, look at the date. That date starts your 18-month clock. Questions? You guys got your chat set to private? In a private chat, tell me A, B, C, or D. More seconds. Let's see what we got. A licensee is on active status, takes one CE class by the June 10th deadline, and pays the renewal fee by June 30th, which of the following is true? Stop. Money first. Did they pay the fee? So their license is current. A current license has nothing to do with education. A current license has everything to do with the money. So A and B, we just eliminated right away, right? Why? Because you pay the fee, your license is current. Failure to pay the fee means your license is expired. Step one, is my license current or expired? The answer to that is if you showed them the money. You've done one CE class. Is that enough? You got an education deficiency. So your license is current. It's going to be inactive because you have a license deficiency. And the renewal period is July 1st. Licenses don't go inactive on June 11th. They will go inactive starting the licensure renewal period on July 1st. So all those people that called me on June 11th and said, I forgot to CE, what do I do? My answer was, get it closed if you can, because you know what's coming. You know your license status is going to change on July 1st until you can get your CE caught up. But remember what I said, many schools don't start offering CE again until August. So you may be taking a vacation until you can do that CE. Does that make sense? Every once in a while you hear a school offering CE in July. You may find them out there. I'm not saying you can't. Questions? Last piece, we kind of bookend this class. Remember one of the first things we talked about back in Unit 2 were timeshares? You know what the last thing is we're talking about? Timeshares. And this is just a real brief, real quick reminder. Timeshares is another one of those things covered under license law and commission rule. You don't need to know the specific law and rule. I just put it here for reference. What's the big thing? Who could show me the big thing we remember about timeshares? You guys are great. What do I remember about timeshares? I don't know what else it means, but 5, 5, 5, 10, jazz hands. Remember that? What's all that mean? The basic definition of a timeshare. You have the right to occupy a unit during at least 5 or more separate time periods over at least 5 years. See here, at least, what I'm telling you is 5 is the minimum. If the test question says 10 separate time periods over 10 years, do you have a timeshare? Yeah, because we had the minimum of 5. That's what at least means. If it says 4, do we have a timeshare? No, because we don't have at least 5. Everybody hear me? There's a 5-day recession period, which means the buyer has 5 days to rescind their contract. The timeshare developer has to have a trust account. The timeshare developer keeps any deposits in their trust account for 10 days. If the buyer terminates within 5, they have to release from the trust account. If they don't terminate on day 10, the developer can transfer it from their trust account to their operating account and do with it whatever they choose, as they choose. And this is the only time that the real estate commission will get involved with matters of money. The only time they can fine a licensee. Questions? Guess what, you guys? We're done. For the most part. We've gotten through all of it. Y'all pretty much know what I know. We're not done though yet. Do not log out. We're getting ready to take a break. I need you to come back from break. Hang on. What's going to happen after break? We're going to go over agent safety. Non-testable, but very important. We're going to talk about the rules and expectations for your exam next Tuesday. And then we're going to talk about how we're going to handle those other 3 units that we've skipped, that we all agreed we're not stressing about, because of the 3, you might see like a test question. So we're going to talk about how we're going to handle those. So I still got more to cover. Please don't go anywhere. If you have to leave early, that's fine. I need you to go back and watch the recording of the exam rules and expectations. I can't stress the importance of all of us being on the same page Tuesday morning. Everybody with me? So if you have to leave early, we're recording. Go check that out. Okay. Go take a break. We'll come back. We're wrapping it up. So let's take 10. Welcome back. All right, so let me take attendance. I'm getting a couple questions about the class or the exam. We'll get there in a second. Let's first talk about safety. And to talk about safety, I want to start. I have a little video for us to watch. Guys, here's the deal. I don't want to scare anybody, but I need to make us aware of the fact that we are getting ourselves into an industry where we're dealing with the public and we're dealing with people that we don't know. And the truth is we need to keep our safety top priority at all times. Unfortunately, not everybody is out there to do good. So we want to make sure that we're safe. We want to make sure that we're protected. I don't want to scare you guys, but I want to be very real with you. And in real estate, this is a very real discussion. So first thing I want to do for this discussion is to watch a video. This is from the National Association of Realtors. They have designated September as Safety Month, and it's a good opportunity to refresh and review. So we're going to watch a little video, and then we're going to have a brief discussion about it. So when I hit play, if I could get some thumbs ups that you guys can hear it, I would appreciate that.
As a real estate professional, you are in a unique position that most working professionals never face. In your business, you often share your contact information openly with others, meet unknown clients, and walk through vacant properties, to name a few. It's because of the unique nature of this business that it's critical for all real estate professionals to have personal safety protocols in place that you follow every day, with every client, every time. So what kind of safety protocols should you implement into your daily routine? Here are a few to consider. When meeting a client for the first time, do not meet a new client at a property right away without first having an initial meeting at your office or a public space, like a coffee shop. During the initial meeting, make copies or take photos of the client's driver's license and pre-approval letter for your records. This precaution allows you to keep a record at the office of who your clients are, their information, and a calendar of appointments. When first meeting with a new client, you should discuss the types of real estate they're interested in and walk them through the safety protocols you have in place for all clients. Now you can arrange showings, meet them at properties, and schedule open houses to help them through the biggest financial decision of their life. When viewing a property, it's okay to ask your client to drive separately. This is a safety precaution for you as much as it is for them. Not to mention you might both have appointments to go to before or afterward.
Hey, this is cute.
As you tour a property, walk behind your client. This routine safety measure allows them to see the room first and make their own impressions. Many agents do not go into attics, garages, or basements as an additional safety measure. But encourage your client to look around and let you know what they think. It is a safe practice to only show vacant properties which might not have electricity during daylight hours. This allows you to see what safety hazards may exist, like a loose floorboard or any defects the house may have.
It's got potential.
When holding an open house, advise your clients to board their pets and remove jewelry, family photos, credit card receipts, artwork, prescription drugs, and any other valued possessions from the home in advance of the open house. This is just one way to look out for your client and to keep their property and belongings secure. Keep a record of who entered the house by asking everyone who walks in the door to sign in with their name and phone number or show a photo ID. There is something to be said about safety in numbers. Consider bringing along a colleague when holding an open house. If there are several potential buyers walking through the home, even better to have 2 agents on hand to answer questions and keep an eye on things. Safety is an important part of real estate. Be prepared and follow the protocols and processes that have been put in place to keep you and your clients safe. For more information and additional resources, visit www.nar.realtor/safety.
All right, so little video. I'll open this up for comments in just a second. Before I do that, I'll go ahead and address the number one question that I always get. And the number one question I get is, can I conceal carry when I'm showing property, open houses, etc.? If you have your conceal carry, you can conceal carry. You know those rules, you know how that works. If you don't have your conceal carry, then no, you can't. Your firm may have a policy whether or not you can conceal carry on their property or not. So we need to follow that policy. But as far as you out showing property, open houses, etc., if you don't have your concealed carry, I want you to have some form of protection on you. I want you to have your mace, or you can get like a little handheld taser, you know, things like that. I want you to have something. So if concealed carry isn't up your alley, guys, I mean, I'm not trying to be funny here. If you're not familiar with guns and you don't know how to work a gun, for the love of God, please do not carry around a gun. Only if you know what you're doing, only if you're comfortable, and only if you're going to practice with it. You're going to hurt yourself or somebody else that you shouldn't have to begin with. Makes sense? But with that being said, I think we should all have something so we can protect ourselves if we need to. I also think every single one of us on this call, by the way, safety, gentlemen, this includes you as well. Please don't think because you're a he, you're immune. I think every single one of us on this call should take some self-defense class. You can find them at local dojos or etc. Maybe you get a team of people, a group of people together, but just to teach you some basic maneuvers on how to get away if you ever find yourself in that situation. The other thing I'm going to say before I open it up, there is no amount of commission worth your safety. And if you don't believe me, just go ask your family this afternoon, and I'm pretty sure they'll agree with me. All right, open it up. Questions? What do we think? Thoughts? Things we hadn't thought of before? And feel free to unmute or type, whichever. If I had a personal experience, I'll call it an incident one time that made me feel very uncomfortable. In hindsight, of course, everything was fine, but at that moment, I felt uncomfortable. I was doing an open house and a gentleman came in. Do people just give you the bad feeling sometimes when they walk in the door? And for some reason, I had a bad feeling. And then he just made a couple comments and stuff that really just kind of had me tensing up a bit. I was on my way because he was touring the house at this point. I think I even got him upstairs. But I was on my way to having to step outside on the front porch and take an emergency call real quick because I could hear people outside. I could hear kids playing in the street. So if I knew if I could step outside and take an emergency call, it would get me out of the house. Before I had to do that, though, another couple came in. So now I was not in home alone with this gentleman. And then he ended up leaving, you know, before they did. I think I ended my open house a little early. I'm not going to lie, I was a little shook. Like I said, I hesitate to call it an incident because nothing happened. And then I spent, you know, time that afternoon kicking myself like, oh, Julie, you're so silly. That guy was harmless. He wasn't going to do anything, da 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 da. And then I was reminded by spouse, friends, peers, family, always listen to your gut. And if your gut's telling you that this doesn't feel right, it's there for a reason. How long has that fight or flight been ingrained in our ancestries? You know, how far back does that go? So, like I said, nothing happened. But yes, there was that one time that it just didn't feel right. And I was working on the plan B, I guess, to get out of that. Outside of that, no, I've not had. And I've been, well, I mean, no. But what I learned from that, you guys, is if your gut's telling you to get out, that's why it's there. That's our fight or flight. Yeah, right. Your firm may have a safety policy in place. They may have a practice for you to follow to be safe. A couple of things, I don't know if you guys picked up on the video or not. A couple things. Never meet a stranger at a vacant house by yourself. Get them to a public place first. Think about it. Somebody calls you and they said, I'm sitting in front of your listing at 123 Main Street. I want to see it right now. Our instinct is to hang up the phone, run out in the car, jump out in the car, and drive over to 123 Main Street. That's not always the safest. So try to get them into the office. Try to get them to Starbucks. Treat them to a coffee so you can get somewhere face to face with them. And I'm going to tell you this. If they're not willing to meet you at a Starbucks for a coffee, I have to wonder their intent. I have to wonder how serious they are about 123 Main Street. So remember, you guys, you are the professionals in this transaction. And if you tell the people that we got to meet at the office before I can show you property, then they're going to follow your lead. But please, please, please. And if you do have to go to the vacant property, take somebody with you. Take a colleague. You can take an unlicensed person with you. Just make sure they understand their role. They're not there to sell the house, that keep their mouth shut. Their job is to just to be their safety in numbers. Yes. If I'm meeting this person for the first time, they want to show property, and I have them come into the office or a Starbucks, what do I have is a really, really good excuse to get in front of them before I show them this property. What's something I need to do early on? Use your working with real estate agent disclosure as an excuse. Everybody hearing me? You can say, I've got to meet you in the office to go over this disclosure and talk about a few things. And once we do that, then we can go see 123 Main Street. Use it as an excuse. The other piece of that, listing agents, we want to, or another piece, listing agents, we want to make sure that we're helping our sellers protect their stuff. When we're doing open houses, I can't always be with everybody every time, the whole time, especially if you have a successful open house. A successful open house means you have multiple groups of people in the homes at different times. Does that make sense? So you got them scattered all over, first floor, second floor, and I can't be with everybody at all times. So have conversations with your sellers, even with showings. I wish I could tell you that all buyers with their agents were with their clients at the all time, but we don't know that. So we want to protect our sellers. As the video said, tell them to put up valuables, jewelry, things that can easily slip into a pocket and walk away. Don't leave grandma's diamonds out on top of the dresser, right? Have them put it away. Have them secure it. Prescription meds. When you put your home for sale, do not leave your prescription meds in the medicine cabinet or the kitchen cabinet over the sink. Do you know where everybody keeps their medicine? In the medicine cabinet and the kitchen cabinet over the sink. So have them put it, lock it somewhere else, especially in the bathroom. We're not going to follow buyers in the bathroom. The next question on your mind right now is, are buyers allowed to use the bathroom during a showing? Well, in case of emergency, what are you going to do? Tell them no? So there may be a situation so stuff doesn't belong where they can get to it. Tell your sellers to put their prescription meds somewhere else, especially for the showing. Have you guys thought about this before? Have you considered this getting into real estate? Some have, some haven't. It's worth thinking about. And again, I really don't want to scare anybody, but we got to be real. We got to be alert. We got to be aware. Be aware of your surroundings. When you get to a property and you get out of the car, look around. Who's across the street? Who are the neighbors out? Don't just laser focus on the front door. Be aware of your surroundings. What else? Okay, we're getting ready to get in exam rules and expectations. I got 3 units left to cover, 13, 16, and 18. I'm telling you right now, you're not going to see 16 and 18 on my test on Tuesday. So I don't want us to worry about 16 and 18 until you're getting ready for your state exam. As far as 13 goes, you can expect to see a question on Tuesday. So let me talk about first how I'm going to handle these last 3 units. Even though you're not going to be tested, not non-heavily tested units, they're right up there with unit 1. Remember unit 1? Forget about unit 1. 16 and 18, don't worry about it until you're getting ready for the state exam. 13, look it over for a test question. I'm getting ready to but I'm getting ready to pause and do exam rules and expectations. After that, as far as I'm concerned, we're done. Class time is over. I'm going to stay on the call though and keep recording. So you guys will have 13, 16, and 18 available for you should you choose to look those over before you go to the state exam. So I will keep going until you guys have all the information on the recording. You're welcome to stay with me, but you're not required to, because as soon as we're done with the exam rules and expectations, then class time is over. But I'm going to keep going, so you guys will have that in our YouTube channel. Fair? Okay. Exam rules and expectations. I just heard from somebody on break. Thank you for reminding me. Have you guys gotten the email from Lane yet? You've seen head shake no, so it doesn't look like we have. You're good, you're good. I got a text into Lane right now saying, hey, when are we going to send this email? So it hasn't come yet. You probably don't have it, or you don't have it. You can expect that email to come out later this afternoon. What email am I referring to? I'm referring to the email that will include the link to access Jane's Zoom for the cram course tomorrow morning. So again, I got a message into Lane during break. Thank you for reminding me. I got a message into Lane. I haven't gotten it. And you guys are telling me you haven't got it. So that tells me it hasn't been sent yet. But we can expect that later this afternoon. Cram course tomorrow from 11 to 3. We had an incident with the recording. Some of you may not be able to attend tomorrow. We had an incident with the recording and the magical powers of IT.
The review games are new.
Have that fixed. So you guys now have the recording for the cram course under the cram folder. If you're not able to come tomorrow, I encourage you to come. I think in person is better than watching a recording. But if you're not able to come tomorrow, you have the recording available under the cram folder in the online learning system. Questions on the cram course tomorrow. Link still to come. We might even hear back from Lane before we're done. Cram course cannot cover everything. It's only 4 hours. And I've been with you guys for 79, 75. So she's going to hit the highlights. What exactly is she covering in the cram course? I don't know. But it's information that you will be tested on. Tomorrow's link, Lane has to email you the link for tomorrow. So tomorrow's link, will she record tomorrow? I doubt she'll record tomorrow because there's a recording available right here. So the link will come in an email from Lane. Again, cram course is 11 tomorrow. So if you don't have it, don't wait till 10:55. First thing in the morning, later this evening, if you're planning on coming, just make sure you give Lane and I enough time to get it to you. Questions? Everybody good? Tuesday's exam, retakes on Thursday if you're eligible. Got our dates, times penciled in. All right, what can we expect on Tuesday? Well, I'm going to give you guys a second because I love this guy and I feel like you guys can feel this guy's pain. I remember feeling this guy's pain when I was getting ready for my end of class exam or my state exam. Right? You guys feel this guy's pain? Lane, I'm working on it now. So we may even have that in our inbox before we're done. So she's working on it. Okay. I'm going to go over our end of class exam. This discussion is not on your state exam. We've already talked about your state exam in the relink section. So the focus on this discussion is your end of class exam on Tuesday. This discussion also applies to the retake if you're eligible. I'm going to ask that you guys please bear with me and hold off on all questions until the end, because there's a really good chance I'll cover your answer before you get to it. I answer your question before you get to it. So can everybody just give me a minute to get it out, and then I will address all questions, I promise, at the end. I got several cameras not on. I don't know if you're here or not, but I guess we need to, I'm going to take attendance so I know for sure who's here, and I guess who I don't know is here or not. All right, attendance has been taken. First, very important thing to know about Tuesday. I'm not available to give you guys your exam Tuesday morning. I got somebody else giving you your exam. You will not log in to my Zoom Tuesday morning. Lane will email you guys on Monday. She will resend you Jane's Zoom link. Jane is going to open up the exam for us, and then another admin with Carolina School of Real Estate is going to help her proctor it. Do not click on my Zoom link Tuesday morning. Did you hear what I just said? I'm not available Tuesday morning. So if you call me, I'm not available. I need every single thumbs up right now that we heard me, please. Thank you. So Tuesday morning, Jane's going to open up the call. Lane will resend you Jane's Zoom link. Jane's going to start at 8 a.m. and she's going to start the check-in process. I will talk about the check-in process in a second. Katie is the young lady that's going to be proctoring you. She's an admin here. Her camera will be off the whole time. You guys will probably never see Katie, but knows that she's in the background watching, monitoring you guys during you take your exam. So we're going to log in on the 21st at 8. We ask that you log in on time so we can start on time. Jane can't start the exam until she has everybody checked in. So please be here on time so we can get everybody started as close to time as we can. The check-in process. Jane's going to need, I think of it as show and tell. Jane's going to need to have a little one-on-one time with each of you. She's going to want to see your basic calculator. Does that say TI-83 calculator? Does that say calculator on your phone? That says basic calculator. If you haven't been calculator shopping yet, please go today, right? Get you a calculator for the exam on Tuesday. Pen, pencil, purple crayon, I don't care, some kind of writing utensil. We'll let you start with 2 blank pieces of scratch paper, and she's going to want to see that the scratch paper is blank. So you're going to show her front and back, both sides, that the paper is blank. We're going to have you start with 2. If you need more than 2, we will allow you to get another piece of paper. I'll talk more about that in a second. Why do we start with 2? Remember, my whole job is to prepare you for the state exam. So how many pieces of paper do you think you're going to start off with Pearson? Exactly. We're going to start with 2. And if you need more, we'll let you get it. I'll talk more about that in a second. Jane may ask you to see your space. She may want to see your tabletop or your desktop. If you're on a laptop, you can lift your laptop and kind of give her the grand tour of your space, your 360. If you're not, she may ask you for the honor system. She may ask you to call in on your phone to show your space. I'm not sure how she's going to handle that, but she will handle it. One way or another, Don't come with formulas taped to the top of your table. Don't come with cheat sheets somewhere. We want to see your space so we can make sure you're working on a clear, clean space. So I don't know how she'll handle that, but she'll instruct you, I promise. I'm fine if you guys want drinks or snacks or cough drops or mints or gum or whatever. Keep yourself occupied. We want your textbooks and notebooks closed and nowhere near you when you're taking the test. I also don't want them in the bathroom because we allow bathroom breaks. So we want to keep them somewhere where you're not only near you, but where you're not going to access them. And then we want your phones either away from you somewhere or off. She may ask you to show, hit the button and see if it lights up. Hit the button and see. This is really the honor system, you guys. So we need you to have a clean space. We need you to have everything, notes and books and flashcards and all that stuff off, put away and away from you. So it's pretty much just you and your device and the test. Remember, I've asked you guys to be in a distraction-free zone. If somebody comes in the room and starts talking to you, we can only assume you're talking about the test. I'll talk about what happens if we think you're talking about the test. Tell your family to leave you alone Tuesday morning. We talked about, I don't want virtual backgrounds or any dimly lit spaces. Jane needs to be able to see you. I don't mind virtual backgrounds on during class, but for the exam, we want those off. We want, some of you have a blurry background. Well, so you'll turn those off as well. That way, if somebody's standing behind you, we can see them. So we want to see that off, no dimly lit spaces. Tuesday morning, you guys are going to shut out everything in your devices. You're going to shut down all tabs. The only thing you're going to open is your email. You're going to use your email to log into Jane's Zoom. Just like you and I have done every morning, you're just going to use that link to log into Jane's Zoom. Once you log into Jane's Zoom, close your email. When you guys check in, the only tab open on your computer should be the Zoom, and it'll be the view that we see in the beginning of class. We'll see it again in a second in the end of class. Once Jane has everybody checked in, then she will release the link for the class marker exam. She'll put that link in the Zoom, or excuse me, in the Zoom chat. You click on the link, and now you only have two tabs open. You have Zoom and you have class marker. I want you guys to minimize Zoom, so all you focus on is your exam. I don't want you guys distracting each other. Katie watches you guys watch your exam. So you can minimize Zoom, get it out of the way where it's not bothering you, and you can just focus on your class marker, your exam. All other tabs are closed. Once the exam begins, that seems like it. Can we talk about that after class, please? Once the exam begins, you have one friend. You have one person you can communicate with, and that person is Katie. If you need to leave in front of your camera for any reason, I need you to communicate with Katie in a private chat. Got to go to the bathroom? Awesome. Communicate with Katie. Need another drink of water? Great. Communicate with Katie. Need more scratch paper? Perfect. Communicate with Katie. All communication is done with Katie via direct message. Never, ever unmute yourself, ever, for any reason. You have peers also taking this exam. And I'm trying to do what I can to help eliminate distractions. So communication is Katie only via direct message. Same thing like we've been doing in class. You'll be able to set your chats to private, set it to Katie. If you need anything, communicate with Katie. Katie's your friend. So Jane gets you checked in. Once she gets everybody checked in, she'll put the link to the exam in the Zoom chat. You click on the link. This is the same program we use to take our midterm. So we've had practice, we've had experience. If you want a refresher on Classmarker, you can find the tutorial in the email from Lane, the one that she sent out that we use every day to click to access this class. There's a Classmarker tutorial if you want a refresher. Jane's link is the same. Lane's just going to send it out again to make sure you guys have it for Tuesday morning. Once the exam begins, you get 4 hours. You have a countdown clock in Classmarker. Keep half an eye on it. I don't want y'all staring at that clock, but I don't want that time to get away from you either. Some of you have shared with us that that clock is distracting, and I agree. Consider having a little Post-it on your monitor to cover that clock up if you'd like. We will let you do that as long as there are no formulas on the Post-it. But if that helps you, if that eases the stress to cover up that clock with a Post-it, we're okay with that. But don't lose track of your time. My end of class exam is 112 questions. You got to get 75%. Break out your T-bar. 112 times 75% will tell you the number you got to get right. When you finish, I want you to make sure you have everything answered. If you bookmark something, go back and get it. If you skip something, go back and get it. You'll remember from the midterm, there's a link that says see all questions, see all answers. I need you to click on that and make sure all 112 of them say answered. Again, if you need a refresher on Classmarker, it's in that email from Lane with my Zoom link. When you're done and you're satisfied that you're done, you hit submit. It says, are you sure? You say yes, and boom, you know right then and there how you did. We'll talk about the different scenarios in a second. Once you're done, you see your score, you know how you did, you're free to go. You can log out of Zoom and go about your day. Katie doesn't have to excuse you. So once you're done and you see that you're done, you're free to go. You'll get your results, the little breakdown of the units, how you did in each unit, and I will also get your results. So I'll be able to check in on you guys later and see how we did. Jane puts the link in Zoom. You click on it. The first thing that comes up is your consent basically to take this exam. I encourage you guys to read this. This is telling you that you can't use any aids, recorded devices, photographs, text, visual images. You can't use a book. This is a closed book exam. You can't refer to your textbook or your notebooks while you take this exam. I think if I could sum this slide up, no cheating. Anybody in violation will receive a failing grade for the entire course and will report it to the North Carolina Real Estate Commission for further inquiry. If Katie or Jane suspect you of cheating, commission says to remove your exam right there on the spot. So just don't do it. Y'all take all that energy into cheating and put it into studying, and you'll do better, I promise. So you're going to read this and you're going to say start, and put in your name, the email address you want your results sent to, again, just like the midterm. So you take the exam, you finish it, you hit submit, and it says, congratulations, you pass. When you pass, you will receive your certificate of completion from Lane. Don't expect her to email you as soon as you take your test. Y'all be patient with Lane. First off, she's got to let everybody finish, not just you. She's got to let the whole class finish before she can process. She will send you your certificate of completion. She's pretty quick. She'll probably get it out to you guys later that day. So she'll have an email, sent you the email. keep that email from Lane, that email with your certificate of completion, because that's what you need. That's the last piece you need to complete your application on the Real Estate Commission's website. So if you're not ready to complete your application now, keep that email from Lane so you know where to find it later when you are ready. If you didn't get the email from Lane, check your spam. She winds up in spam sometimes. I don't know why. So keep that email because that's the information you need to go to your state exam. That would be a Lane question. I have no idea. So if you pass, Lane will be in touch with the good news. If you don't pass, but you make at least a 50%, then you're eligible for the retake on Thursday from 9:15 to 1:15. If you're eligible for the retake, Lane will be in touch. You will get an email from Lane on further instructions on how that'll be handled. The rules for the retake are the same. The exam is not. Remember our end of class exam review PowerPoint in the Julie folder covers both the end of class exam and the retake. If you don't make at least a 50% on Tuesday, you're not eligible for the retake. If you don't make at least a 50%, Lane will be in touch about some options that you have going forward. No matter your outcome on Tuesday, Lane will be in further touch with you. Just be patient. I promise you, Lane will get with you no matter how you do. Yes, if you need more paper, you send a direct message to Kate. Lane will be in touch if you pass. Lane will be in touch if you're eligible for the retake. Lane will be in touch if you're not. Lane will be in touch. The other thing I have to say, the what ifs. What if Katie loses power? What if you lose power? What if you lose internet? What if anything goes wrong during the exam? Stop and breathe. If you lose connection for any reason, they're going to put Katie's phone number in the chat for you guys. And they're going to ask you to write it down on your scratch paper before you begin. So if you lose connection for any reason, breathe, turn your phone on, and call Katie. We will get through it. I can't predict. I don't have a crystal ball. But I do know no matter what happens, we will get through it. I promise you that. Doesn't that sound like good advice to tell your buyers and sellers too? We will get through it. And you know what? We will. I don't have the answers yet, but we will. What questions do I have about the exam? Just my end of class exam, please. Again, you guys, the sooner Jane can get everybody checked in, the sooner you guys can start. Thumbs up. We're logging in at 8 o'clock on Tuesday. May I offer some tips and tricks? Oh, good. We got that Zoom link for tomorrow coming in. Awesome. Thank you. Don't check your email right now. We're still talking. May I offer you guys some tips and tricks? The number one piece of advice that I can offer you on Tuesday is to breathe. Anybody else in here do yoga? Y'all know what a big part of yoga is? breathing. Short labored breaths. You're going to flip a question. It's going to happen because test stress is a very real thing. Test stress is a very real thing. And you're going to see a question and you're going, I've never seen this before in my entire life. Stop and breathe. Take a couple big, deep breaths in through your nose, out through your mouth. Get yourself at a place where you're thinking. Short labored breaths are not how you clear your mind. So breathe. The second big piece of advice I have for you is to read. Breathe and read, read and breathe. I need you to read every single word of the question. I need you to read every single word of all the answer choices. Remember, you always have the ability to bookmark a question. So if a question seems like too much for you to deal with right now, bookmark it and come back to it later. It gives you time to think. It gives you time to simmer down. But you know what? There may also be a future question that triggers something for you that helps with that previous question that you skipped, right? So sometimes bookmarking it and going on, keep it moving. This is what I'm telling you guys. Keep it moving. You may see a future question. Oh yeah, Doy, I knew that, right? So use the test to kind of help yourself a little bit. Do not change your answer unless you're absolutely 5,000% sure that it's wrong. How many of you have changed a right answer wrong? Stop it. Stop it right now. It's so easy to second guess ourselves, you guys. And seriously, if you read a question, you know in your heart of hearts that it's C, why are you going back to it? You've just set yourself up. If you don't know in your heart of hearts that it's C, that's the one that you bookmark. If you narrow it down to 2, maybe that's the one that you bookmark to come back to. But if you know everything about you is screaming C, by going back to it, all you're doing is setting yourself up to start second guessing yourself. Make sense? Once you say it's C, it's locked in unless you're like 5,000% sure. Before you submit your exam, make sure that you answer any skipped questions. That's that see all questions or see all answers link that's available. I've also suggested that you guys always save the math for last. So when you go to the next question and all 4 answer choices are numbers, don't even read it. Just bookmark it. Why are you reading it and wasting your time? If it's a math question, bookmark it, and then you know you're going to do that for the last. Go back to the non-math that is bookmarked. I recommend you save the math for the very last, once everything else is answered. And of the math, the how much does your buyer have to bring to closing should be last. As we said, take your time, but watch your time. Keep an eye on that clock. If the clock stresses you out, put a Post-it on it. But keep your eye on that clock. Keep your eye on that time. Between now and Tuesday morning, how many anybody's weekends plans involved staying in the book? That's all you're going to do this weekend is study, right? Yeah, that's not going to help you guys. I can't have you spending all your waking hours studying. I need you to put the book down. There is such a thing as overstudying. And if your plan right now is to spend the rest of Thursday, all day Friday, all day Saturday, all day Monday, look it over real quick Tuesday morning, I promise you, you're going to be over it before you ever start. So at some point in the next 4 days, 5 days, put your book down and go outside. Go to lunch. Go do something. You can't just study. Don't spend all of your waking hours studying. We're also not going to pull an all-nighter. So I need you to go to bed at a decent hour Monday night. Get a good night's sleep. At some point Monday night, you got to put the book down. At some point Monday night, you have to know that you know what you know. And at some point Monday night, you got to relax. What does that look like for you? Get you a good sleep Monday night. Again, if you're up all night studying, you're going to be too tired. You're going to be over and you won't do well Tuesday morning. I also want you guys to get some breakfast Tuesday morning. I don't want you listening to Tummy's grumble. Don't go to Golden Corral and get you a buffet breakfast, but get something, some kind of light breakfast. You're not sluggish, but you don't usually have. I don't want you to be distracted by your stomachs. You got to fuel the machine. And the last thing, I got some questions coming in chat. I will get to those. But the last thing I have to say to you guys is best of luck to you guys. This is only a missing piece of your real estate journey. Remember, we did not complete your whole puzzle in this class. We gave you many pieces, but we scratched lots of surfaces. This is just the beginning. Step 1 is getting you through pre-licensing. Step 2 is getting your state exam, and onward you go. Also, after the exam, Lane will send you guys all a survey. It's anonymous, so we encourage everybody's honest feedback. Survey is going to be on myself. It's going to be on the school, the different tools that we offer. We encourage you guys to be honest because that's how we grow. And that's how we can offer a better product. That's how we continue to be better. So we encourage you guys to be honest. It's helpful. And like I said, it's anonymous, so you don't have to worry about hurting my little feelings. I'm tougher than that. I'm in real estate. What's Tay-Tay teach us? You gotta shake it off. Take it for what it's worth, grain of salt. But it allows us to grow. It allows us to see where we can improve. So we really appreciate you guys taking the time doing the survey. So some questions. Let's see. Is your exam covering everything we covered? No. So to help us focus on my exam, we have this PowerPoint under the Julie folder called the End of Class Exam Review. There's more in the syllabus than what there is in the End of Class Exam Review. And as I said, this applies to the exam on Tuesday. This also applies to the retake. Somebody's asking a question about reading out loud. I'm okay with that. Understand when you get to Pearson VUE, you can't, you can move your mouth, but you can't talk because you got somebody next to you taking the exam. So you may be whispering to yourself, and that's what I would prefer. You know, if you're reading aloud, does anybody do that? I do too, especially when we're concentrating, right? Reading aloud to yourself looks different on our end than having a full-blown conversation with somebody else in the room. Like I look at a couple of you right now and you're talking to somebody, I can see you. That's different than, you with me? So make sure that we can see that difference between reading silently to yourself with your mouth moving versus having a full-blown conversation with somebody in the room. That's fine if that's what you got to do. Pearson exam, do you bring paper? Do they provide it? They provide it. One thing at a time. Before we go to Pearson, we got to get through this next week. If we need more paper, do we message Katie? If you need anything, you message Katie. What else? What other questions? If you're on an iPad, sometimes the Zoom link on the iPad doesn't work. So if we lose you, we may just have to have you call in on your phone. We may have to have you on 2 devices, but that's going to be a case-by-case thing. And sometimes we won't know how that's going to look. So if you click on the exam and there's an issue, there's a problem, reach out to Katie. She will get you through it. We will get through it. I've enjoyed you guys. I thank you for your time. I appreciate your insight and your feedback. I've enjoyed this class. Best of luck to you guys. I hate that we have to part ways here today. Although I won't be with you on Tuesday physically, know that I will be with you. I'll be off on the sidelines cheering you on, absolutely. I'm still available for questions. up until Tuesday morning, so don't hesitate to reach out to me this weekend. And the whole reason why I do what I do, I look forward to getting the text from you guys that says, Julie, I passed my state exam today. That's why I do what I do. So make sure you keep me informed, keep Lane and I informed. Again, we're always here to cheer you on. Even when you're getting ready for the state exam, we're still here. So never discount us as a resource. And I guess the next time I'll see you guys is post licensing. How does that sound? There's your carrot, post licensing. Guys, as far as I'm concerned, class time is over. If you want to go, you're welcome to go. Attendance is officially stopped now. I'm going to stay on the call. I'm going to keep recording so that way you guys will have access to 13, 16, and 18. It's been my experience. I can probably bust through them in about an hour. 3 units in an hour. Compare that to the 3 days we spent on unit 7. You guys are with me, right? We see the importance of these. So I'm going to stay on. Actually, I got to go get some more water. And then we're going to come back and we're going to do chapter 13. You're welcome to go. Otherwise, we'll see you guys in post. We'll catch you guys on the other side. If you're sticking around, awesome. If you're sticking around, bear with me. I got to get some more water so I can talk for a few more minutes. And then we're going to wrap up those units we didn't get a chance to cover. And we're going to start with unit 13. So if you want to find that in your book, and I'm getting this, and I just need like 30 seconds to go. Okay, so let me go get water. Thank you. There we go. Do you guys see that now? I don't know if it's my Zoom been messing up lately. If it's okay, water. Okay, thank you guys for that. Thank you for sticking around. I appreciate that. I know you get it both ways in the recording, and quite frankly, if you still have to go somewhere between now and the time we're done, I can sit here and talk to myself all day. So, but I appreciate you guys being here as we finish this up, sticking around for however long you want to. Chapter 13 is our homeowners insurance unit. This is our homeowners insurance agent hat that we're going to put on. Again, just so we have a basic understanding of property insurance to help advise buyers and sellers. So in this unit, we're going to talk about, there's some different types of homeowners insurance. We're going to talk about some insurance issues. So to start on 372, we want to define some words. Insurance is the bilateral agreement between the insurer and the insured. It's a contract between the two parties. The insurer is the insurance company. The insured is the homeowner. And the relationship, their agreement, the insured pays the insurer and agrees to reimburse the insured should something happen to the property. If the buyer is getting a loan, a home loan, insurance is required. Period. End of story. The lender will require insurance to protect their interest. If it's a cash buyer, or when you pay that policy off, when you pay the lender off, when you pay the lender off, insurance is highly recommended. It's only required if an agent or if a lender is involved. Premium is the consumer's cost. What does it cost the insured to pay for the coverage? Your premium is your cost to be insured. Couple more things to define. Property insurance is also known as casualty insurance. Property insurance is what protects the insured, causes damages caused to the property. So property insurance covers the property. Liability insurance protects the insured from losses or damages caused by third parties. So if you have somebody come on your property and they get hurt or they damage your property, the liability insurance is there to cover that. So the package insurance then is a mix of the two. It covers property and the liability. Lenders require a certain level policy. They have minimum standards. Lenders have to approve or sign off on the insurance policy that the borrower is going to get. We want our buyers to start shopping around for homeowners insurance during due diligence because the lender has to approve it. And if we find out that the lender doesn't approve it or the premium is more than the allowed amount, the approved amount, I'd rather find out that we're not going to be able to purchase because of homeowners insurance while we're in due diligence. So at least I can get my buyer their earnest money back. So have them shopping around. Not all people, not all properties are easily insured. If the people or the property have a claims history, their premiums might be higher. And if they're too high, we don't get loan approval. If we don't get loan approval, we can't buy. So we want this secured and happening during due diligence. There are several different types of policies out there. They're listed on 373, 374 of your book. I'm not going through all of them, but we do want to just hit on a couple. I mentioned that homeowners have a minimum coverage requirement. They got to approve the policy. Most lenders will approve the most common policy is referred to as an HO3, excuse me. So this is the most common policy. This is the one that satisfies most lenders' minimum coverage. But this also is the one that provides the insured with the greatest amount of protection. So again, HO3 is generally speaking going to be the one that most lenders are looking for. They will tell your buyer if this is an acceptable policy for them or not. They got to sign off on it. And the lender is going to be in communication with the homeowner's insurance agent as well to get that payment, to get it set up, to get it started, all that good stuff. So the lender's got to know who you're selecting to your insurance agent is, so they know who to reach out to. A couple other policies, just to show you there's some differences. The HO4 is renter's insurance. This is the tenant's policy. Renter's insurance doesn't cover the property or the structure. It just covers the tenant's stuff. So the homeowner, the landlord, is going to have homeowner's insurance on the property. The tenant is going to have their stuff insured. HO4 policy may cause any damage that the tenant may cause the property if it's written in the policy, if it's part of it. And then another one that just kind of stands out to us a little bit is the HO6. And this is our condominium owners, our condominiums policy. This one is also referred to as a walls in policy. Remember, condo owners own from sheetrock to sheetrock or paint to paint. So it doesn't cover the structure, the whole building. It just covers fixtures, walls in, and the stuff in. Questions about the different policies? Again, you got them all here. You can flip through it real quick if you want. Let's define some more words. Condition is a limitation on coverage. An example of a condition might be a vacant property. I'm going to talk about vacant properties in just a second. But a vacant property would be an example of a condition. An endorsement, you could add an endorsement or add a rider to your policy that covers something that's not normally covered. For example, something rare or valuable. If you had grandma's jewels or, you know, something antique maybe, and you wanted to add an endorsement, that would cover that thing that is not typically covered. And then in exclusion, there are certain events that are excluded typically from our policies. So if this event happens, they won't offer you coverage. For example, most homeowners insurance have an exclusion that excludes the coverage of loss due to acts of war or terrorism. I mentioned earlier, not all people, not all properties are easily insured. One thing, whenever you're applying for homeowners insurance, whether you're just buying a house or you're shopping around for new policies, one thing that the homeowners insurance agent will always consider is something called a CLUE report. And CLUE stands for Comprehensive Loss Underwriting Exchange. And the CLUE report is a database. And it has a history of claims from the last 7 years. So we said if the people have a history of claims or the property has a history of claims, and where we're getting that information is from the CLUE report. I'm not saying you can't get insurance if you have a history. What I am saying is you may have a higher premium if the property or the people have a history of claims. And again, if that premium is more than your allowable monthly payment, we're not going to get loan approval. So I'd rather find this out with due diligence. Nobody likes to terminate. That's a fair statement, right? Nobody likes to terminate. But as a buyer's agent, if we have to terminate, the best thing I can do is terminate in due diligence. At least I can get my buyers their earnest money back. Let's talk about vacant versus unoccupied property. There's a difference. A vacant property is one that is completely empty. The people and the stuff have been moved out. The people and the stuff are gone. And in unoccupied, the people may leave temporarily, but the stuff is still there. They'll be back. I have an uncle. We call him a snowbird. Do y'all know what that means? 6 months out of the year, he's living in Pennsylvania. 6 months out of the year, he's living in Florida. He travels south for the winter. He's got a property that's unoccupied. The stuff is still there waiting on him to come back. We, as brokers, want to encourage specifically the homeowners. If the homeowners are going to leave the property vacant, At some point, they have to move out, right? They got to move out before closing. If they're moving out a day or two before closing or settlement, this probably isn't a huge deal. But if they're moving out months before closing, if you're listing this thing vacant and you've never seen them live there, we want to encourage the homeowner to reach out to their insurance agent and report the property as vacant. Their premiums will probably go up during that time, but here's the deal. Vacant properties are more susceptible to theft, vandalism, because they're vacant. And if the homeowner doesn't report it as vacant and something happens to the property, the insurance company may not help them out. The insurance company may say, you should have told me it was vacant, so we could have offered you additional coverage. I can't make anybody do anything, but I can, with documentation, tell my sellers that I highly recommend that they contact their homeowner's insurance company and let them know that it is vacant. Does that make sense? You guys hear on the news, where do they take copper wires from? It's not an occupied home. It's not a well-populated area, right? Vacant properties are really good. Theft, vandalism, etc. If it's going to be unoccupied, you may want to consider them. Not as much of a concern. There is a little bit more concern with unoccupied, but not as much concern. Vacant is the one that we want to make sure that we're telling our sellers, we're looking at our sellers and say, contact your homeowner's insurance agent. The other conversation we need to have with our sellers, listing agents, the other conversation we need to have with our sellers is that they got to maintain homeowners insurance until that deed changes hands. The risk of loss covered in our offer to purchase and contract. It is still the seller's home until that deed changes hands. So the risk will remain on the seller. The question is, what happens if the house burns down when we're under contract? What happens if the tree falls on the house while we're under contract? Sellers need to still be insured to protect what's their still interest. If the property is damaged, the contract spells out the buyer's options. The buyer can elect to terminate. And if they do terminate because the house burns down, they'll get their earnest money and due diligence back. They'll just be out the cost of their due diligence, inspection, surveys, etc. If the buyer does not terminate because the house burnt down, we go on to closing, the buyer gets the property, and in addition to the property, the buyer gets the proceeds of the seller's insurance claim. So the seller would still file the insurance claim, and the payout now would go to the new owner. If the house burns down, buyer's agents, your buyer's going to look at you and say, what should I do? Pull out the offer to purchase and contract and read this risk of loss provision. Give them their options, let them know what their options are per the contract. And then tell them to talk to their attorney before they decide which option to proceed with. So what's all this mean for us? We need to encourage our property owners to talk to their insurance agent, especially if they're going to leave it vacant. Can't hurt to mention if it's unoccupied. But again, the big risk is vacant. And then listing agents, it's worth telling the sellers to maintain coverage through the day of closing. There's a common misconception out there. Think about it. The sellers have coverage to the day of closing. The buyer's coverage starts when they become the owner. And the common misconception is that the home is doubly insured on closing day, but it's not. Somebody's responsible until the deed is recorded, and then the buyer picks up. So if the house burns down on closing day, it's probably going to come down to what time did we record the deed and what time did the fire marshal say that the house burned down? You guys with me? They're not both going to be able to file. It's going to be who was the owner when it burned down. Question comes in, is it our duty to make sure the deed has been delivered by hand? Nope. Once it's recorded, that's the buyer's acceptance of the deed. So once it's recorded, that's evidence of their acceptance. Questions so far? Just got a few more things to say about homeowners insurance, but let me pause here. Another situation that may come up, we briefly talked about these in Unit 10 as well, because I got a form for both of these situations. But we may have a situation where possession doesn't happen at closing. Possession meaning that's when the buyer's moving in. And we may have a situation, if the parties agree, to do a buyer possession before closing, which means the buyer moves in before we close. We may have a situation to do a seller possession after closing, which means the deed changes hands and whatever reason the seller remains. I got a form for both of these. So as you guys, if you ever encounter these situations, know that there's a form for that. Read it. But basically the big thing that this form is covering, these forms are covering in these scenarios, in either scenario, somebody's acting as the landlord, somebody else is acting as the tenant. Buyer possession before closing, it's still the seller's property. They are the landlord renting this property out to the buyer until we get to closing. Seller possession after closing, this one's tricky. Think about it. You're going to stay a couple days after closing. Today, you're the owner. Tomorrow, you are the tenant of the home that you own for the last however many years. Interesting, right? Either party, no matter what your role, whomever acting as the landlord needs to have homeowners insurance. Whomever is acting as the tenant needs to have tenants insurance. We got to make sure, and that's a big thing what these forms do, is make sure that everybody is adequately covered. These situations, the forms that we have available are designed for short-term situations. We're talking like a couple days, maybe a week. These forms that we're using are not full-blown leases. They don't cover many terms that are covered in a lease. This is just meant as a solution for a couple days. If we're going to be longer than short term, then we either need to use a pre-printed lease provided to us by NCAR or have an attorney draft something up. Another thing that may come up with homeowners, property owners that we need to be aware of is flood insurance. Flood insurance is really expensive. If the property is located near a body of water, then it may be in a flood zone. Flood zones are determined by FEMA. FEMA is the one that says whether or not it's in a flood zone or not. There are so many maps available that allow us to look to see what FEMA says. Is it in a flood zone or not? If it is in a flood zone, the lenders will require flood insurance. If flood insurance tips them over their allowable monthly payment, we're not going to get loan approval and we have to terminate. I always try to look at a flood map before I ever write an offer up, because I want to know if we got to deal with this or not, if we have to have this conversation. Again, they're available, various different sources. But other than charge for flood insurance, FEMA does more than that. If they have an area that's susceptible to flooding, like every time it rains, it's floods, they may work with the area to try to improve that, see if there's something that we can do. FEMA is federal. So again, FEMA who's give us the different flood hazards, what is susceptible to flooding, and whether or not that's what triggers the insurance agent to know if they need to charge flood insurance. So flood insurance, you guys, is provided by FEMA. They allow the homeowner's insurance agent to provide it. We encourage our buyers to shop around homeowners insurance companies. Tell your buyer to talk to Jake from State Farm and Flo from Progressive, right? Have them shop around. But when it comes to flood insurance, there's nothing to shop for because it comes from FEMA. FEMA tells the insurance agents how much to charge. And FEMA doesn't pull this number out of the air. If you will, turn with me real quick to page 378. Here, I'm going to say possibly. It depends. On page 378, the top of 78, you guys see those bullet points? Year of building construction, occupancy, number of floors, etc. This is kind of like the algorithm that FEMA uses to determine how much insurance to charge. And this is why we say we can't shop around, because it's dependent on the property. So the algorithm, the information is put into the system. And then beep, boop, boop, it tells you how much flood insurance should be charged for this property. How old is it? Where is it located? There are maps available, various sources. You will get those from your firm when you affiliate. But this is just an example. Do I have Winston-Salem people left on the call? People familiar with Winston? No? Okay. If you know Winston, you know this intersection because this is 421. Back in the day when we were in person, we were actually here. This is Stratford Road. This is Knollwood. If you know Winston, this is Thruway Shopping Center. And Chick-fil-A is right, or actually I should say was right there. Have y'all driven by there lately? They leveled it. I guess they're rebuilding a new one. There is no Chick-fil-A. I was by there yesterday. I was like, what the heck happened to Chick-fil-A? They're getting a new Chick-fil-A. Very exciting. Anyway, this is Winston. I just show you this. Here's 421. Also referred to today as Salem Parkway. And the other side of 421, you're in a residential area. And in this residential area is our flood zone. So if I was helping my buyer buy in this area, my flag would go up. Do you see how close to the flood zone we are? I'm not the expert. I'm not FEMA. I'm not the lender. I can't tell you if flood insurance is required. But what I can say, if you're buying this house right here, that's close. We need to be aware that this might be something that we have to deal with. Does that make sense? If you're up here, I'm going to say we're okay. That's why we want to look at a map. I'm not giving guarantees. I'm not making promises. I'm not telling you, but I'm just saying, based on this map, you look awfully close to a flood zone. It may come up. The lender may require it. 100-year floodplain is flood insurance speak, and it's really misleading. 100-year floodplain does not mean that it floods every 100 years. That would be too easy, right? What the 100-year floodplain means is that it has a 1% chance of flooding annually. So if it's in a 100-year floodplain, like we're looking at here, that means there's a 1% chance every single year that area could flood. Flood maps change. If an area has never, ever, ever flooded before, and then we get a downpour of rain for 2 weeks straight, nonstop, and the area floods now it's in a flood zone because there's a chance that it could flood because it's already flooded. Does that make sense? So flood maps update. Flood maps change as things flood that have never flooded before. And that's why we always encourage, even if you're familiar with the neighborhood, don't rely on what you know. Things change. You owe it to this buyer to pull the flood map, just like you owe it to that one and that one and that one over there. All right, let's bring this home. What's all this mean for us? We can use our little red flags. Again, I'm not a lender. I'm not a flood insurance expert. I'm not FEMA. But I can use my little red flags to find possible signs of flooding. What are possible signs of flooding? Bodies of water. Is a property near a lake or a pond or a river or stream or a creek? We know what these fast moving spring thunderstorms can do that come in fast and hard, right? Streams turn to creeks, creeks turn to rivers, rivers turn to these angry, gushing bodies of water. Any body of water would be a red flag for us to talk to our buyers about it. Once we find out a property is in a flood zone, we now have a material fact. Listing agents, this is part of your checklist with the seller when you list the property. And it's really a twofold question. Is the property in a flood zone? And are you required to pay flood insurance? Just because it's in a zone, now the question is back to our algorithm, how close to the body of water it is. I had a property once, it was like 5 acres. The top of the 5 acres was a creek. The house was at the other end. So we're like total ends of the spectrum here. The creek was up here. The property was in a flood hazard, but the property was way down here. They didn't have to pay insurance. So just because it's in a flood zone, I mean, it's 5 acres away, you know, so just because it's in a flood zone is no guarantee that we have to pay flood insurance. What's the material fact? The fact that it's in a flood zone. That's what we have to disclose. And yes, that is a required field in MLS. In other words, you can't activate the listing without answering yes or no, it's in a flood zone. What if the buyer doesn't want to buy in a flood zone? Then they got to come up with the cash. They're not going to be able to get a loan. The lender will require it if it affects the property. Listing agents, we need to have this conversation with the sellers, encourage them to keep homeowners insurance through the day of closing. They got to keep that coverage until that deed changes hands. Buyers agents, if we said, let's get them shopping around for the policy while we're in due diligence. You can't assume everything's going to be okay. So again, buyers agents, the best thing we can do is protect our buyers. Have them shop around. We know the lender has to approve it. We know the lender has to sign off on it. Why delay? Don't wait till after due diligence, find out they're not insurable. They have to terminate, and then you're the one that has to look at them and say, sorry, you're not getting your earnest money back either. Remember those gears? Keep all those gears going. Y'all, it takes a village to buy a house. Keep the villagers going. Keep everybody moving. Material fact, how do we disclose material facts? There's no commission roll on delivery. The only thing they say about material facts is we have to disclose. How do you disclose? I don't care. Just get it out there and make sure it's documented. That's unit 13. That's the longest of the three. 18 and 16 won't take us that long. With that key point review, key terms, and student quiz. Absolutely. So you have your reference. Again, you guys, test question. You may want to look over your notes super quick before Tuesday morning, but I need y'all studying 7 and 8. Do we hear the difference? Test question. Questions on 13. And I need to stop sharing for just a second while you guys are thinking of questions. Moving right along. Unit 18. The hat we get to wear in 18 is our accountant's hat. This is our accountant's unit. Is anybody a CPA? Is anybody an accountant? Awesome. Then we cannot offer accounting advice. We cannot offer CPA advice. If anything comes up about taxation, anything with taxes, this is a stay in your lane. And we need to advise our clients to talk to their accountant. CY other A. We've CY'd several A's, right? We've called your attorney, we've called your accountant, and we're covering your assets. You see what I did there? Cover your butt. Am I available this weekend? Absolutely. Absolutely. Shoot me an email, shoot me a text. I may not get back to you immediately, but I promise you I'll get back to you when I can. I got to turn it off at some point, right? All right, so accountant hat on. What do we need to know? Basic understanding of taxation. We're going to identify some tax benefits of homeownership, whether you're using it as your personal property or an investment property. And we're going to briefly mention some of those deductions. And then the other piece of this unit is to talk about your capital gains. I know that word says calculate, but everybody breathe. We're not actually picking up a calculator. So we just need a basic understanding of what the words mean. We do provide you formulas just because some people have a math brain and other people have a I can read this brain. So one way or another, we're going to get it to you, right? So we're not picking up a calculator, but we do need to understand what adjusted basis, amount realized, and capital gains are. So this section, this unit is pretty much broken down into two sections. The first section is dealing with tax benefits for personal residents. If you're currently a homeowner, talk to your accountant to make sure that you're getting all the tax deductible expenses that you can by being a homeowner. You may, I'm not an accountant, but you may be able to get some tax deductions on your mortgage interest, whatever you pay for interest on the mortgage. You may be able to get tax deductions the year you buy your house if you pay discount points. Discount points, remember, are prepaid insurance, or no, prepaid interest, sorry, prepaid interest. So the year you buy your home, you could be eligible for what you pay for discount points because discount points are interest. Make sense? So that may be a tax deduction for you. If your lender charges you a prepayment penalty, that may be tax deductible. Your insurance premiums. And again, the year you buy your home, some of your loan origination fees may be tax deductible. Agents, brokers, tell your buyers that first year of ownership, what does it hurt to talk to an accountant? That first year of ownership, just to make sure that they're taking advantage of the tax deductions of buying and of being a homeowner. The other thing you may be able to take for tax deductions the year you buy and for the rest of your ownership may be your real property taxes. So again, talk to your accountant. Have your buyers talk to their accountants. Questions on tax benefits for your own personal residence? The second piece of this unit are different tax considerations when you're selling. And this is where we're going to define some words. And then we're going to break these down into formulas in just a second so we can see how these words play out. Capital gains is the amount that you realize from the sale of your home. You could have a loss. If you sell for less than what you bought it for, you could suffer a loss. So ideally, what we're all shooting for is a gain. It's the amount realized from the sale of your home. Capital gains compares when you bought it, what you did to it when you owned it, and what you sold it for. So your cost basis was your initial cost. What you paid for the property back in the day when you bought it is your cost basis. Capital improvements are anything that you do to add value during the time that you owned it. The best way to add value is to add square footage. So if you finish the unfinished basement, if you build a room at the back of the house, those would be examples of capital gains, something that adds value. Adjusted basis is your cost basis plus your capital improvements. So your adjusted basis is your cost basis plus your capital improvements. And that gives you your adjusted basis. Your amount realized is what you sell the property for. So your adjusted basis is what you paid for it plus what you added to it. Your amount realized is what you sold it for. The difference of the two is your capital gains. When it comes to tax consideration when selling your property, there's a difference in whether or not you were considered a short-term ownership or a long-term ownership. Long-term ownership is defined as somebody that owned the property for more than 12 months. Short-term then is less than 12 months. Who is typically the person that owns it for less than 12 months? Typically. I'm going to venture a guess. Yeah. The flipper, the investor, the person that comes in, their job is to come in, buy a house, flip it, and sell it. They're typically the ones that are short-term owner. They own it for less than 12 months. These tax considerations when selling, capital gains and all that, that's not going to apply to short-term ownership. Those tax deductions for the flipper are rolled in as just the cost of doing business. They pay taxes, they and part of their business and does. So they're not going to be able to get additional tax advantages. They're already getting their tax benefits from their ordinary income. Short-term ownership is not eligible for capital gains. Only long-term. So if you've owned it for long-term, you want a capital gains. First off, it needs to be your primary residence, your principal residence. A married couple filing jointly can realize up to $500,000 tax-free capital gains. I'll say more about that in just a second. A single person or married couples filing separately can realize up to $250,000 tax-free for their capital gains. And when we define a principal residence, the IRS says that you have to occupy it at least 2 out of the last 5 years, and those 2 years don't have to be consecutive. If the amount of time that you occupied it during that 5 years adds up to 2 years, then you could be eligible for capital gains. So let's take the words we just defined, and let's put them in a formula so we can see how we can realize our capital gains. So first off, we need to find that adjusted basis. Remember, the adjusted basis is your cost basis or your purchase price. Add to that any allowable closing costs, whatever your closing costs were when you bought it. Purchase price and allowable closing costs is your cost basis. Your cost basis plus your capital improvements, the value you added to it while you bought it, gives you your adjusted basis. So what did you pay for it, including your closing costs? What did you add to it while you owned it? That is your adjusted basis. When you sell it, what you sell it for, minus your allowable closing costs, give you your amount realized. So the adjusted basis looks at what you put into it when you bought it and what you did to it while you owned it. The amount realized looks at what you sold it for. The difference between the two is your capital gains. If your adjusted basis is bigger than your amount realized, then you have a loss. So we're going to look at an example. Again, we're not going to pick a calculator up. Y'all put your pencils down for just a second, give your hand a break, and let's just talk through this example. Let's bring this home. So the original purchase price was $398, and you had $1,550 in closing costs. 20 years later, you sold it for $920,000 with $600 in closing costs. Problem does not mention capital improvements, so we're not going to deal with capital improvements. So your purchase price plus your original closing costs give you your cost basis. Your sales price minus your allowable closing costs gives you your amount realized. The difference in the two gives you your capital gains. You have capital gains this year, $519,850. What does this mean in the tax world? Well, if you're a married couple filing jointly, you have $500,000 tax exempt, which means you're not going to be taxed on the $519,850. You're going to be taxed on $19,850. That's what we mean by that $500,000 and $200,000 for the exempt. So now you're taxable. Your capital gain is $519,850, but your taxable capital gain is $19,850. Pretending that the tax rate this year is 15%, that means your tax bill for your capital gains for the sale of this property will be $2,977.50. Much better than if we were taking 15% on the $519,850. If you're single or if you're married filing separate, then your tax exemption would be $250,000. So that's where that comes into play. Again, however your brain sees it. Do you see the formulas or do you see the definitions? We're saying the same thing. It's just a matter of how we're viewing it. Questions? This is the unit where, yeah, y'all know what I know. So if you ask me a question, I'm very well may talk to your accountant. This is the The last little piece, or last two pieces, there's some special rules that may apply for tax deductions. Again, if you or any of your clients come into these situations, we may want to encourage them to talk to their accountants just to make sure that they're reporting everything and they're getting those benefits. Home offices. Since the pandemic, a lot more of us have home offices than what we did. Home office portion of the home may be used for a tax deduction. So if you have a space in your home that's used for your business, there are certain criteria to get with your accountant. But you may be able to write off a portion of the home for the home office. You guys see my write-off. This little corner right here, this is my home office. All the business happens back here. No fun whatsoever. No, that's not true. I always try to have fun. Life's too short not to have fun. Agree? Go have fun. If you're doing an installment land contract or an installment sale, we talked about those in Unit 10. Those installment payments may be tax deductible. Remember, the buyer's buying, but they're not paying one big purchase price. They're paying in installments. So those might be tax deductible. And then if you own a property as a vacation home and it is used as a vacation home, meaning it is not your primary residence, but you're allowing others to use it for vacation properties, that those expenses, those fees may be tax deductible as well. Again, there's rules. Like, for example, to claim a vacation home, I believe the owner can't occupy the vacation home more than 14 days out of the year. If you do that, then it wouldn't qualify as a vacation home. So again, before you can, just get with the account because they can give you the specifics about what qualifies as a vacation home and what doesn't. Tax deferred exchange, also known as 1031 exchange. This is also known as like kind exchange. This is the tax program for investors. So if you're an investor or you're thinking about being an investor, if you want to work with investors, we need to encourage our investors to talk to their accountant about the 1031 program, tax deferred exchange. What's going on here? The IRS will allow an investor to sell an investment property, use the proceeds of the sale of that investment property to purchase the next investment property. And as long as they're using the proceeds of this sale to buy another investment property, they may be able to defer paying those taxes. It's a like kind exchange, property for property. It doesn't have to be condo for condo, property for property. There are rules. The accountant can help. I know there's a certain amount of time that you got to buy the next investment property. I want to say it's 6 months. Don't hold me to that. If you don't buy the next investment property within 6 months, then you're not going to be eligible to defer paying those taxes. Great program for investors. Last thing to say in this unit, we talked about depreciation in Unit 17, and we said it's an accountant's tool. So it makes sense that it pops up here again. The accountant is going to figure out depreciation. Remember, depreciation is the loss of value for any reason. We talked about physical deterioration, functional obsolescence, economical obsolescence. Those are things that cause the building to lose or the property to lose value or to depreciate. And the accountant may be tasked with figuring out the depreciation schedule. How much value do we think we're going to lose in this property each year that the property is around, of its effective life. And the simplest way, the most common way for accountants to do this is something called straight line depreciation. So if we determine that this property is going to have value for, I'm making numbers up, this property is going to have value for 50 years. Let's say the cost of the property is 1.5. They would take the cost of the property, divide it by the number of years that we expect it to have value, and we would figure a depreciation schedule of $30,000. And what that $30,000 means is that every year for the first 50 years, it's going to depreciate 30,000. Year one, it's going to depreciate 30,000. Year 3, year 17, year 24, every single year for the next 30 or 50 years. Straight line depreciation says this is how much it's going to depreciate. Again, an accountant tool to help them with those taxes. And this is the simplest, the cleanest straight line depreciation. It's an equal amount over the structure's useful life. Through 18. Key terms, key point review, student quiz. I wouldn't worry much about this until after Tuesday. Questions? Last unit, 16. This makes me sad. This is one of my favorites. I find this one the most interesting, but we're going to blow through it. When I say basic residential construction, I don't know what's less than basic, right? We're not like scratching surfaces. We're scratching like big major topics here. Again, you guys, just basic residential construction. There's so many classes and resources out there for us to learn more about residential construction. So we just want a very basic understanding because buyers ask questions. Buyers point at stuff in homes and say, what's that? So we want to have this basic understanding to help answer their questions. Also note that that word says residential. Commercial properties are generally built different. So we're just focusing on building the house. So we're going to talk about some basic architectural types and styles of residential construction. And then we're going to identify the major components of a house foundation and framing. So to first talk about some different styles. There are so many different styles of properties. You can have ranches, split levels, 2 stories, contemporary design. There's split foyers. There's a style out there to meet everybody's needs, satisfy everybody. Ranch homes, all of the main living level is on one level. So kitchen, dining room, living room, bedrooms, bathrooms are all on the main level. Maybe the ranch has a basement, maybe it doesn't. But everything is on one level in a ranch. In a split level, your main living area, living room, bedroom, kitchen, is generally on the main level. And then about halfway through the home, you encounter a staircase that's going to split the other half of the home. And generally speaking, your bedrooms are on the second story of the split level. And then the lower story down here may be partially below grade property, but it may be like a bonus room, a den, maybe the laundry room's down there. Maybe we've converted it to another bedroom. But your living room, dining room, and kitchen are on the main level. Compare a split level to a split foyer. A split foyer is a 2-story house. And when you walk in the front door, you got 2 choices. You go upstairs or you go downstairs. The 2-story home, bed or living room, kitchen, dining room are going to be on the first floor. Maybe your primary bedroom is also on the first floor. Upstairs, you're going to have your other bedrooms if your primary is not up there or down there. So you have your other bedrooms, maybe a loft, maybe a bonus room, something like that. And then a contemporary is a more specialized, a more unique design. Getting with a builder typically to have, you know, your dream turned into the reality. Again, you guys, there's not one better than another. Bottom line, these comes down to buyer's preferences. If your buyer doesn't want to deal with stairs, I suggest sticking to ranches. If your buyer wants their bedroom on the second floor, maybe we need to look at a 2-story, right? These are good questions we can ask them, or those that we will learn as we're out with them showing property. Most residential construction in North Carolina is wood framed, which means our skeleton, our bones are wood, and that wood is going to be treated. We don't want unwanted guests moving in. So treated wood is going to help prevent against termites, for example. Wood is used the most. It's generally the less expensive than a steel framed, for example, that commercial uses. But wood also gives the builder flexibility of design. They can get a little bit more creative. They have more flexibility when working with wood. So benefits. And of these 4, the one that is, typically speaking, the one that is the most expensive to construct per square foot. How much does it cost us to build these 4 houses per square foot? And the one that is typically going to be the most expensive is the ranch, because the 2 most expensive components about building a home are the foundation and the roof. And with the ranch, you got everything on the foundation, you got everything under the roof. A 2-story may be the same square footage of a ranch, but it uses half the foundation, half the roof. Does that make sense? With the roof and the foundation be now, obviously contemporary can get really expensive really fast. I think we can all agree with that, right? So, but typically speaking, per square footage, because the ranch utilizes the maximum square foot roof and maximum foundation. So this is our house, and we're going to break this thing up into 3 chunks. I don't know if you guys want to take a screenshot or something so you have it to refer to it. Of course, you got my PowerPoints in the online learning system as well. But we're just going over some basic components of the house. We're going to take this and break it down into sections. And just like builders, when builders are building a house, they always start with the foundation. Start from the ground, build your way up. The very first thing that goes down in the foundation, before the foundation, are footings. We're going to dig out trenches. And then footings, we're going to pour in maybe concrete. It's going to give us the foundation for the foundation. How about that? The footings help support the foundation. The foundation rests on the footings. The footings, the trenches got to be dug out below the frost line so we can account for the earth expanding and decreasing as the weather changes. The further north you go, the deeper the frost line. Basements are more common up north than they are here. Yes, we have basements in North Carolina, but they're more common up north than they are here because we got to dig so far down anyway. If we're digging that far, heck, might as well carve it out and throw a basement in. Either way, no matter where you are in the country or the world, we got to get you below the frost line. On top of the footings goes the foundation. Couple different types of foundations that we'll talk about next. But the foundation is usually concrete, cinder block, brick, what we're looking at here. The foundation is rests on the footings. If your foundation is a crawl space or a basement, you might have piers. And piers are what we're looking at here. And they just help offer support. We don't want the floor to eventually sag in, cave in, right? So piers just help support the weight of the whole home if we're on a crawl space or a basement. A couple different types of foundations. The crawl space, we're going to lift the living level above the ground. It allows for ventilation, moisture control. This is a nice crawl space, by the way. You can get in there and treat your crawl space. If you leave it untreated, you're looking at like, dirt. It's sitting on the dirt, built on up. Crawl space and basement, unfinished basement, control and preventative measurements. What we're trying to prevent here is moisture. We don't want the moisture to lift up from the foundation to the home. Ventilation is key in keeping everything dry. A basement then is just a story high crawl space. So if you have a crawl space that's a story high, then we can call it a basement. If it's finished, it can be livable. If it's unfinished, it might be used for storage. And then with a slab, exactly how it sounds. You carve out the footings, pour down concrete, and then you build right on top of the concrete. We're not lifting the house up. Again, this comes down to preferences. Some people prefer a slab. Some people want the crawl space or the basement. It's worth us asking questions, what our buyers want. One disadvantage to a slab, when they're pouring the concrete for the slab, they got to come in and put the fixtures for the plumbing and electrical and things we got to run from the street to get to the house. So they pipe it, they plumb it, and then they pour the concrete around it, which means we can't come in and move the piping. So if you want to remodel your bathroom, where that bathroom sink is where it is. In a crawl space or a basement, you can get underneath the house and get to the plumbing. And if you want to move the sink from this wall to this wall, you have that flexibility to do so. But with a slab, once it's poured, it is where it is. From the foundation, we build on our foundation. These sills are the lowest horizontal piece of wood. The sills offer support. If they're unbalanced, if they're uneven, then we can use girders to help level it. So girders, sills offer support. On the sill or the girder goes our floor joists. These are gonna attach to the sills, the floor joists, and they're gonna support the entire weight of the floor. On the floor joist, we put the subfloor. The subfloor is like particle board, plywood, something like that. On the subfloor, we put our flooring. So what are you and I walking on? Carpet, tile, laminate, cork, hardwood. What we actually see, what we actually walk on goes on the subfloor. From the floor framing, we start building our wall framing. Studs are the skeleton of the home. Studs are the bones. The studs are the vertical pieces of lumber. This is where we start to see the shape of the home. Have you guys ever heard the saying that as long as the bones are good, then the house is good? When we refer to the bones, we're referring to the studs. So as long as our framing, our studs is in good shape. The sole plate is what connects the stud to the subfloor. The top plate is what connects the stud to the ceiling joist. Today, studs are required to be 16 inches apart. That hasn't always been the case. So you may find an older home that has different studs. But today, they're going to be 16 inches apart. And then headers are horizontal pieces of wood that help support an opening. So if you have a window or a door, we got a gap, right? I got a hole. And we want to make sure that that opening is supported. So we're going to put a header on the top just to offer that support of the weight. I always think of it this way. The headers prevent the windows and doors from falling on your head. Absolutely. Thank you. We'll see you in post. So the headers stop the house from falling on your head. We're going to fill those open places for windows and doors. Different couple types of framing systems. Platform is the most common. With a platform, that's what you're looking at here in this picture. Each floor is framed separately. So your first floor is framed, your second floor is framed. Each is framed separately. Perfect, thank you. See you in post. I'm not too far, you guys. If you need to go, I understand. I'm committed to the end. So you can always pick it up on the recording. Like I said, I could stay here and talk to I do talk to myself on the regular, so this is really nothing different for me. Balloon framing, the studs, it's a 2-story home and the studs go from top to bottom. They're not separate flooring. It's one really big piece of lumber that's 2 stories long. That's balloon framing. And then post and beam framing uses a different lumber. It's usually a thicker lumber. I always think of post and beam framing as like, think of like our mountain lodges. I picture like a lodge where you can see the rafters and the ceilings. That would be a post and beam. Thomas Kincaid homes sometimes look like that. See in post. Thomas Kincaid homes look like that post and beam. So just a different kind of lodgy feeling to it. So we built our foundation, we built our walls, framing. Now we got to frame our roof and our ceilings. Ceiling joists are connected to the studs by the top plate. By the way, top plate, sole plate. Where's the sole of your feet? Where's the sole of you? It's at the bottom. So where's the sole plate? It's at the bottom. Think of your sole of your shoes. So where are we? Ceiling joists support the weight of the roof. Connect to the property from the top plate, help support the weight of the roof. Rafters are the sloping members that create the shape of the roof. Maybe even a triangle shape gives us our rafters. Ridge board is the highest point of construction. The ridge board is as high as you go. And the whole reason why we want sloped roofs to help divert the water away from the property. Water and homes, structures are not good. So whatever steps, whatever measures we can take to keep the water, keep the moisture away from the property could elongate the home. Eaves jut out from the house, the overhang of the roof, to help direct that water away. The components of the eave. The soffit allows ventilation. It's usually got like a bunch of little holes in it and allows ventilation. If you go outside in a minute when we're done and you stand flat against your house and you look up, you're going to be looking at the soffit. The freeze board, again, also helps with moisture control, keep water away. The freeze board might be a little bit more decorative, maybe start to give the house its looky look. But we're trying to prevent penetration into the attic. And then the fascia board is what we connect the gutters to. So the gutters connect to the fascia board at the edge of the eave. The gutters are a big way to help direct water away from the home. Runs into the roof, runs from the roof into the gutters drive it away. Questions about any of our framings, foundation, wall, and roof? I got studs up. Now I got to put walls on them, our exterior walls. Sheathing is going to be added to the wall frame, to the studs, particle board, plywood. On top of the sheathing, the old school way to do it is to use tar paper. Today, we're using house wrap more and more. What you're looking at this picture, this white, what is it? Certainteed, that's our house wrap. Cutting out holes for windows and doors. On top of the tar paper or the house wrap goes our exterior siding. Vinyl, brick, stone, whatever it is we see from the street. You'll notice, for example, like vinyl, we'll see this in our roof. Vinyl is laid in such a way that aids in the water running away. We don't want it turned up to allow it to pool or collect. Homes have windows. We got a couple different types of windows. Sliding windows either open up or they've opened to the side. With a sliding window, you have one section of the window that moves. In a swinging window, they open out. They may have a little crank and you crank them out. Maybe there's an awning over them. And then when you want to close them, crank them close. And then fixed windows don't open. Fixed windows are picture windows, which is what you're looking at here. Just allow us to see the scenery. Windows have components. The window sill is the bottom. The bottom of the window is the sill. The header is the top. Where's your head? Your head's on top. And then the window jamb are the sides. Each side is the window jamb. In a sliding window, the piece that moves is called the sash. So if your window opens up, that piece you lift up is the sash. Muttons and mullions. I always feel like these are made up words, but they're real. Buttons and mullions are the cross hatches of the windows. So your muttons are your horizontal cross hatches, your mullions are your vertical. Muttons horizontal, mullions vertical. Houses have doors. Your exterior door is different than your bedroom door. Your exterior door is different than your closet door. We want the exterior door to have strength. We don't want somebody to come kick it in. it's not uncommon for your bedroom door, your closet door to be hollow. Our exterior door should be solid. The finishes of the door, a flush door is a smooth finish. A panel door is what you're looking at right here. Kind of gives it a little more decorative. A sliding glass door would be a glass door to access maybe a patio or a deck. And then French doors are more of an upscale decorative design. They have glass panels in them. I always picture French doors going from like the kitchen to the formal dining room, for example. More of an upscale design. Good news, the components of a door are the same as a window. The sill is the bottom, the header is the top, the jamb is the sides. We're close, you guys. Some components of the roof. The decking, remember the rafters, the sloping members that form that triangle shape? The decking goes on the rafters. This might be plywood, particle board. On the decking, they put down roofing felt. It's got to be something sticky, for example, tar paper, because the shingles go on the roofing felt. And like we said, with our shingles, you can see they're laid in a way that allows the water to flow or the rain to flow down to help get it diverted away from the home. The pitch of the roof is the slope of the roof. Rise over run. Rise over run tells us how steep it is. This is a pretty steep roof right here. But the pitch tells us the slope. By the way, shingles are typically asphalt or maybe fiberglass, maybe shake. They're usually asphalt. Homes have to have insulation, help regulate heat, AC, help with temperature control. The old school insulation were the big pink bats, and you got those rolls and you just roll them right on out. We've progressed. We're starting to see more and more use of loose fill or blown in insulation, which is what the Pink Panther's doing here. So they blow it in and then it kind of hardens in place. Another thing that's gaining in popularity is foam. So again, same thing, kind of the foam in and it expands and hardens, fills in the gaps, anything that might be allow air or water to come through. Weather stripping is used around exterior doors and windows. Have you ever been sitting in an old home on a drafty day and the curtains move a little bit? Yeah, we should get some weather stripping. We don't want those drafts. It kills our power bills. So if you see your curtains moving, weather stripping also helps with doors. Again, for temperature control, but can also help keep critters out. Critters don't need much space to get in. So if you see, if you see any light, pin of light coming in through your door on the side, get you some weather stripping. And then moisture control, we're looking for moisture controls in the basement crawl space and also in the attic. Ventilation is the best way of moisture control if we could keep air going. We saw that picture of the crawl space a few minutes ago that had a water vapor barrier, that white plastic looking stuff. That helps keep the moisture in the ground and not come up into the home. Again, cannot stress the importance of moisture control in a home. Moisture's only good, water's only good for living things, you guys. In a property and a structure, it can do some serious damage. Also with insulation, North Carolina, our standard building codes. Insulation is measured in something called an R value. The more resilient to heat, the higher the R value. So the current building codes have the highest R value in our ceilings, trying to keep all that heat from the sun from coming down the roof and penetrating into the home. So you're going to have a higher insulation R value. If you go up to the mountains, you may have a higher R value as they tend to get a little cooler. Current building codes then says that the minimum R value for the walls is the R13, floors R19. We can always do more than that. We can always have a higher, but this is just the minimum codes. We may have heating and air conditioning systems. We may have both. The HVAC system is a combination of the two. HVAC stands for heating, ventilation, and air conditioning. It utilizes both. How we source the HVAC, gas, oil, electricity, maybe you have solar panels. If you have a separate heating system, heating and air systems are separate, then we don't have an HVAC. So let's break these down. Separate heating systems. Older homes may have central forced warm air. There is no ductwork. There's a centralized heating system, and the air kind of, or the heat kind of penetrates throughout the home from there. No ductwork. Gravity warm air could be like a central furnace, very similar to central forced warm air. Again, you don't have those duct systems pushing heat out throughout the home. It's all in one centralized location, the home. Older homes, definitely. Also in older homes, you may find electric baseboards. They run at the base of the wall. When you turn them on, they generate heat. Space heating systems could be kerosene heaters, gas heaters, wood stoves, radiators. Radiators are those coil things that generate heat. Those suckers get hot. And then solar heating systems. You could have a solar heating system just for the property, or you could have a large solar farm that's capturing energy to use. Later, we're starting to see those solar farms pop up. If you're familiar with Winston, out there off of Clemensville Road across the street from Hobby Park, there's now a huge solar farm. Also separate, we may have a separate air conditioning system. So you may have a central forced air. You may also have window units. The HVAC combines them. If we don't have an HVAC, we have two separate systems. Most homes built today are going to be built with the HVAC, with the combined. Back to our combined, back to our HVAC. The heat pump is used to pump heat and air inside the home. We reverse it during the season. It pumps heat into the home, and it pumps the heat out of the home in the summertime. So the heat pump works both ways, depending on the season. BTUs are just how they measure heat. British thermal units. They're stated in thousands. The higher the BTUs, the more space we have to heat. The bigger the space, the larger the area. We're starting to see, like, well, not starting to, but in like this century, we're seeing, like, for example, 2-story homes, they have a dual heating system, one for the first floor, one for the second. We all know heat rises, right? So if we just have one, you're working hard all day to heat the second floor. But if you can get one on each floor, the one downstairs is going to be bigger, the one upstairs will be smaller, but at least, and you have different regulations, different thermostats for each floor. That'll help with your power bill. When you're showing property, if you want to know if you got a dual heating system, well, look outside, you'll see 2 units sitting out there. But when you go inside, you'll see a thermostat downstairs and a thermostat upstairs. And that'll tell you you're dealing with a dual system. And then the last thing with residential construction are various governmental regulations. Again, how builders build today, yesterday, and tomorrow is all regulated by the North Carolina Uniform Residential Building Code. The building code's main purpose, it gives us a construction standards for safety. Safety is the #1 priority, the #1 focus with these building codes. They can and do change over time. HUD has different minimum standards. We talked about, like, FHA and VA loans have different standards for HUD or for properties to get those loan types. That's because HUD is involved. So financing, we could have some different. And then we got our general contractors, our GCs. That's a separate license, test, examination, all that stuff. But if you're doing a major project or if you're building, there's a really good chance you hire a GC, and then the GC subs out the work. So the GC coordinates with the electrician and the plumber and the sheetrock guy and all the people in between, and coordinates when they're going to each come in and do their thing based on the stages. Unit 5 or 6, unit 5 or 6, we looked at the minimum in North Carolina. If your project, not the minimum, if your project is 30,000 or more, we said that we need a GC involved. We got to have that lien agent involved to help coordinate the project. Because again, if it's 30,000 or more, you're dealing with the plumber, the electrician, the sheetrock guy, maybe the foundation guy, the painter, right? You're dealing with more than one guy. So that lien agent will come in and help will help coordinate that. And with that being said, now y'all literally now know what I know. That's it. Key terms, key point review, student quiz. I would not do too much with unit 16 until after Tuesday. What questions do I have? I appreciate you guys staying with me. Thank you. What questions do I have?
So just, I might have missed this earlier, but unit 16, all the building material stuff, there's not going to be a lot of that on the final exam?
No. Question maybe.
Okay. Yeah, because I took the practice final and it was like, I got like 10 wrong from that. And I was like, oh, I don't know. I guess we didn't cover that yet.
Well, remember your end of class exam review
Yeah.
helps you kind of pinpoint what you can expect to see Tuesday and Thursday if necessary.
Gotcha.
State exam syllabus covers everything.
Okay. Awesome. Thank you.
Of course. Guys, that's it. Y'all ready for lunch? Goodness, I'm ready for lunch. I was prepared for today. I had a good breakfast, so I knew. But I'm ready for lunch. You guys, seriously, if I can answer any questions, don't hesitate to reach out to me. Best of luck to you guys on Tuesday. I'm with you in spirit. I'm in the background cheering you on. Know that I'm there. Yeah, and then we'll see you on the other side in post licensing. That's what's next. Bye. Thank you.